Well, I'm delighted to have such a big turnout. This is wonderful. This is a program about which I feel very passionately, just like our other mediators. I think all of the mediators that we have really believe in this process, and we've seen it. Honestly, I think work miracles. I've had the privilege of mediating over 100 of these cases, and some of the things that have happened in these mediations have really been profound. So my background, I've been licensed to practice for over 25 years, and I did actually practice for about 17 of those years, mostly as a civil deputy DA. Funnily enough, I really never did dependency for the DA's office, except occasionally I'd have to run in there and appear. I did lots of other things, but for the past 8 or so years, I have been a mediator. I have a wide spectrum of cases, custody and dependency and guardianship. I'm a Supreme Court settlement judge, and those are every kind of cause of action in the world. A lot of human resources stuff. But my heart really is with dependency. It's one of my absolutely favorite areas. And why is that? It's because this is an area where people really need to be able to have a voice. Not just parents, but children need to have a voice at the mediation table. And mediation is really the only way we can provide that in the dependency setting, because you don't really get a voice in court so much. So I realized one more thing. For a while, kind of by accident, I served as a pro tem on the dependency docket in Reno for about 3 months. I didn't love it because I decided I don't really like to make the decisions. I like to empower people to make decisions. But it gave me a lot of really valuable insight into what it's like from that side. And I've been able to incorporate that into my practice, and I might talk about it a little bit today. As I prepared this, I realized, wow, 3 hours, that's a long time to fill. I like to present CLEs, and my CLEs are usually really interactive, lots of video clips, try and make them as entertaining as possible. And I hate to disappoint you, but I can't really do that very much here because I have to talk about a protocol. So we'll have a few videos, but a lot of this really is going to be explaining to you guys the structure of the program, what we're looking for from each of you, and the best thing I could think of to help out with that was to insert some stories along the way of cases that I've seen that maybe illustrate the point I'm trying to make. And I've asked Jay and Kathy to jump in. They seemed kind of reluctant, so I hope they might jump in at some point. And then I would really like to be hearing from you. This is absolutely my first experience in implementing a statewide program. What I've learned is that different jurisdictions do very different things. So I've mediated kind of across west-east rather than north-south, so in Elko and Lovelock and Fallon and places like that. And each jurisdiction has its own little quirks. I did have the opportunity to mediate a case here on Wednesday. So I've seen just a small little window into what it's like here. But it's really important for me to hear feedback from you about what's working, what's not working. We are doing things a little bit differently down south than we do them up north. And so I want to make sure that what we're doing is working. And I know we have had some bumps along the way. So interaction from you guys will also be super helpful as we go along this morning. So I will at least start us off with an activity, because I know I can do that. This is just a quick, fun little activity. So I want you guys to all find a partner. Just turn to the person next to you. It's going to be easiest. Those of you with the table, this might be a little bit easier than others. All right. All right, already that's caused a ton of chatter. Here's what you're going to do. You've got your partner, right? You're going to assume the position. This is the position. You have 2 goals. You get 1 point if the back of your partner's hand touches the table, and you want as many points as possible. You don't care about anybody else. Ready, set, you got 30 seconds. Go. All right, time. All right. So, who thinks they got the fewest points? Okay. Who thinks they got the most? All right. So fewest points. What was your technique?
I caved.
You caved, and how was that?
She was just much stronger than me. I saw her look in the beginning. I was intimidated.
Well, Lydia is very intimidating, as I found. So, how did you get points? Through strength, brute strength?
Yeah, I didn't get any points. I got 3.
Lydia?
Well, so the judge actually said that he let me win because he was a gentleman.
So that was my excuse.
So he got points for letting me keep my dignity.
Aha. Yeah, there are points for that. All right, how about another set of folks who think they got the fewest points? Like maybe 0.
Me?
What was your
Well, I had an excuse. I was using my right hand on left hand. So that started my list of excuses. The other excuse was that, she's a nice lady. I didn't want to beat up on her.
How about who you just went for the traditional arm wrestling game of strength? You guys? And how'd that work? How'd that work? Pretty well. All right. So how many points did you get?
I got the 1 point, and then it was just.
You went against somebody who has neck problems.
Choose your
So I
partner
took advantage of
wisely.
that.
That's a negotiation strategy right there.
Saw my opportunity.
All right, so Jay, I saw you guys over here getting a lot of points. How many points do you think you got?
22.
22. Wow, what was the difference? What was your strategy?
I didn't care if he got 20, if I got 20. So we just went back and forth. I got my points, he got his.
So thought a little bit outside the box, right? So what you guys just experienced was a negotiation. And there are several types of negotiation. There's the positional bargaining, hardball, win-lose. Those of you who did that traditional brute strength, that was hardball, win-lose negotiation. But there is also interest-based, integrative, principled bargaining, which is what we're going to be talking about here today. So those people who just did the back and forth and thought outside the box a little bit, that's what they were engaged in. So what on earth does this have to do with mediation? Mediation is just an assisted negotiation. It's a problem-solving conversation facilitated by mediators who are specially trained neutrals. They assist the disputing parties to develop and reach a mutually acceptable agreement. So let's talk a little bit about styles. This is kind of what comes back to this negotiation style that you just experienced. There are multiple styles of mediation, but I'm only going to highlight 2 for purposes of today. There's evaluative. So this is based on settlement conference model. It's when the mediator evaluates the case. The mediator might make recommendations, might not, but the focus of the case is the legal merits. So how many of you folks have been in an evaluative mediation before? Yeah, probably most lawyers. I absolutely have been in evaluative mediation. And when I first started mediating, that's what I thought mediation was. And then I realized, so there's a whole world of styles out there. So the other style that we're going to talk about is facilitative. That's when the mediator assists the parties in having the conversation. So the mediator here controls the process, might direct people where to seat, kind of help people figure out who's going to speak first, decide if there's going to be a caucus, things like that, controlling that process. But the parties control the content here, so it's very different. So the focus here is not on the mediator evaluating merits, giving an opinion, anything like that. The mediator instead is trying to help the parties focus on what their interests are and what their needs are. So this is the kind of mediation that we are using in this program, facilitative. It's about getting to the needs of the parties. So we'll be talking about that a lot and what that means in these cases. But it's really a different mindset for all of you who are going to participate, that we're not focusing on, you have a good case, you have a bad case, or here's what I think the judge might do. It's instead, what do you need from this? What are you looking for? What does the future look like? So let's explore a little bit more about facilitated mediation. So one of the hallmarks of actually any style of mediation is self-determination. The parties have self-determination. Anybody want to take a stab at what that means?
Parties come to their own agreement and try to reach a consensus agreement.
Right. The parties are the decision makers. So this is one of the biggest difference between court and mediation, and one of the reasons why mediation in this area is so powerful, because it lets the people at the table, and I'm not just talking about parents, I'm talking about everyone at the table. I'm talking about the DAs and the social workers, CASA, everybody at this table has a voice, and everybody is part of the decision. And the mediators are never there to force anybody into making a decision. And we'll talk about that a little bit more. So facilitated mediation is collaborative. This is not about advocacy. There's plenty of time for advocacy. You guys all have, I'm sure there are some very powerful advocates in this room. And there's a time for that. There's always the courtroom for advocacy. But it doesn't work well in mediation. It is voluntary. And you may say, how can that be? We've been ordered to be here. How do you guys think it can be voluntary in this context?
You're ordered to show up.
That's right. You don't have to stay, and you don't have to come to a decision if it doesn't work for you or your client. The way that mediators, at least facilitated mediators, define a successful mediation is not based on whether or not it resolved. That took me as an attorney a long time to adjust to because we're so result-oriented as attorneys. As a mediator, however, I'm not so result-oriented, I'm process-oriented. So for me, a successful mediation is, did I put everything in place and use every tool in my toolbox to allow these folks to have a meaningful conversation, to explore what's happening, what does everybody need, what are the options that might work here. That's a successful mediation. So mediation is confidential. I'm going to address confidentiality a little bit at the end because it's so important here. It's important in every mediation, but I think especially important in dependency because parents are not going to be able to come to the table and feel comfortable being really candid about maybe what was happening in their household or what they're looking for in the future with regard to their kids if they are worried that these words are going to be used against them, put in a court report, or talked about in open court. So the confidential nature of these is really important. It's informal. I'm certain that my mediators, like I do, really strive to make this the most comfortable process for people, the most unlike court possible. I always refer to mediation as anti-court because for me, it's the opposite. I refer to myself as a recovering attorney because even though I stay licensed, I don't feel like what I do is related to practicing law anymore because it's not about proving that point. It's not about advocating. It's about bringing people together. So we try to make these mediations as comfortable and un-court-like as possible. And for me, here's really where my experience serving as a pro tem has helped because I can remember watching parents walk into that courtroom and they just look like deer in the headlights. I think from their perspective, here they are parenting their kids, making some really poor choices, but parenting their kids in their own little world, and then all of a sudden, kids are removed and all of these eyes are on them, talking about how you're raising your children. And that has to be so disconcerting, so painful, so challenging. And then, here they are thrown in the courtroom setting. They're not even really speaking on their own behalf most of the time. They've got someone else speaking for them. And they don't really understand what's going on. The hearings are super fast. Everybody's talking. They're throwing out a bazillion terms. I think dependency has more acronyms than any other area I've ever dealt with. And they're lost. So this is such a great way to slow down, to slow things down, get everybody around this informal environment, let people have a voice, and see what unfolds. It's a really flexible process. Some of the stories I talk about today might illustrate mediators are, every case is different. You never know what you're stepping into. Even if you do a lot of prep work, you don't know what you're stepping into. You're really working in the moment. And so you may determine, at this point, we're in joint session, but it's really going to work better if I can separate out for a little bit. Or I sometimes might just pull the attorneys from the case and have a conversation if I think that's going to move it forward. We're going to take breaks when anybody needs breaks because this is so emotional for parents. It's this really fluid, flexible process, but that's what makes it work. It's a really empowering process. I kind of talked about this already, that I don't think court for parents or for kids is often very empowering. When someone else is speaking on your behalf and you're not allowed to just stand up in court and say, Your Honor, here's everything that's important to me. Here's really what I want to talk about. Here's what I want you to know. Nobody gets to do that as a party in that courtroom, and it's disempowering. So total opposite here. Everybody has the floor, and for enough time to really be able to fully voice what they need to voice.
I think the empowering cannot be overestimated. Dependency and engaged. That's what we're trying to do as a system. We're going to get those parents engaged. It's just give them a piece of paper that show up at counseling and refer to really get them. How can we help you? I think the empowering is the real key for dependency, because you get family engagement, you can resolve those issues and get those kids home safely, or keep them home safely and resolve the issues, so it's just not the next kid, the other kid, to really help it, than just taking all these people's children away from them.
Absolutely, and for them to be able to have a say in where their case is going and how it progresses is another part of that empowerment. It does give buy-in, and we'll talk about some studies that have shown that. So it's very constructive. This is meant to be, and I really want to bring this home to everybody here. This is meant to be a process where everybody participates. This isn't just about parents coming in and having their voice. This is about everybody at that table. Everyone's perspective is important. So I don't want, for example, deputy DAs to get this idea of, okay, this process is for the parents and that's great, it's good for them, and I'm just going to kind of watch this. We need everybody there. We need everybody brainstorming, everyone looking at this. And it's also a great time for parents to understand social services perspective, the DA's take on the case. That's equally important. We're there to foster a greater understanding of everybody. So we really want everyone engaged and talking and participating in this process. It's very forward-looking. I always say mediation is this mix, this funny mix of the past, the present, and the future. You got to talk about some of the past because that's what has brought everybody in the room. And sometimes there needs to be some clarification on the past, or there needs to be the telling of this is my version of what happened in the past, and it differs from your version, but it's important for me to tell that story. So there'll be some piece of the past that's going to be talked about in the mediation. The present is what's happening right here, right now in the mediation. But the majority of what the focus needs to be on is the future. Because we can't ever undo the past. We can let people kind of vent, maybe make some peace with it. But the idea is to let them do that so they can move forward into the future. And being able to, part of the mediator's toolbox is to get people out of that loop they sometimes get caught in the past and get them forward-looking, and it can make a huge difference in the case. And if you're doing this at the beginning of a case, like at the initial petition stage, that forward-looking piece is so important because there's so much of that case still left to be worked through. They've got to do their case plans, all the things that go into these cases. And if you can get parents forward-looking, then that's what they're going to start. They're going to start doing. They're going to start engaging in that case plan. And you've probably already gotten the idea that it's really impactful on the kids, on really everybody, and on I think, a bigger scale. So I just want to put this slide in because sometimes there is confusion, and I always want to make sure it's clear. And even as a lawyer, I don't think I ever paid attention to the difference between arbitration and mediation because as a government lawyer, I didn't really do a lot of either. And so I don't know how clear my head was, and I just want to make sure that your heads are clear on this. So arbitration, ordered by the court. Mediation is either voluntary or ordered by the court. We've talked about that. In arbitration, the neutral is the decision maker, just like in a courtroom. In mediation, the neutral is just the facilitator, not the decision maker. There are somewhat formal rules in arbitration. The whole idea is due process. So kind of mini courtroom. In mediation, as we've said, really informal and flexible, and the parties have a lot of input. As we talked about earlier, the parties have input on the content. So arbitration is going to be based on law and evidence, and mediation, again, based on those interests. What do people need? Judge. Okay. Arbitration, very win-lose. It's kind of like that arm wrestling you guys just did, right? It's whoever has the best evidence or whatever it is going to be the winner, and the other person's going to be the loser. Mediation, we are always looking for that win-win. How do we find a resolution that meets everybody's needs and interests? Oh, boy, well, we're just batting 1,000 on the technology today. All right, so what are the objectives for dependency mediation? I think Judge Sullivan, really hit on this. It's about getting engagement, getting children permanency faster. That's absolutely the goal here. It all comes back to the kids. It's about getting those cases unstuck. You've all probably seen it when parents get stuck on a piece in the case. Like the initial petition stage, they're stuck on that petition. That's not really how it happened in my house. And they hyper-focus on that when they really need to be focusing on, here's my case plan. Here's what I'm supposed to be doing. Or they get stuck at the end where I'm going to fight for my kids no matter what. And they are unable to step back and look at that bigger picture of what's really going to be best for my children. So anytime there's some kind of hearing set, something that's being disputed, the case is stuck. The way this process is supposed to work and hopefully will ultimately work here in the 8th JD is anytime a case is stuck anywhere along the line, from the initial petition all the way to TPR, it can go to mediation. That's our model in the 2nd JD. It's a good place to exchange current case information. Sometimes things can happen really quickly in these cases. Medical stuff, maybe a new family placement option has cropped up, or the ICPC suddenly got approved, things like that. Good place to give that exchange. If it's a situation where parents haven't seen their children in a long time, that's something that we often will start with in the mediation is, how are the kids doing? Tell us what the kids are doing. Parents want to hear that information. You've probably gathered it's a chance for everybody to not only speak and talk about their perspective, but also to listen. I cannot tell you how many cases I've had where the mediation, the information that's coming out in the mediation, it's information that parents have heard time and time again. It's been talked about in the courtroom, it's been talked about in their meetings with their caseworker, it's been talked about by their attorney, but they aren't able to hear it. There's still that deer in the headlights. It's not gelling. Something about that mediation setting, maybe because of the way they're able to participate in it, they can suddenly hear things for the first time that they just have not picked up on. And maybe it's because we're able to really set aside this time and make sure that everybody thoroughly understands and can ask questions. And I mean, there aren't a lot of times in the courtroom where people are, raising their hand, I have a question. It doesn't really work that way. So this is very, very different. Mediation, one of the great advantages of it is we can not only look at legal issues, but we can look at other issues. If there are other things, it's not unusual for us in an initial. I hope we can just ignore that. In an initial petition case, to maybe first focus on the petition, talk about what's not working. Can we, come up with a document that everybody's good, and then the parents are ready to submit. Then we might move on to something like visitation. If we're all sitting down at that table, I want to use that time to try and deal with all of the issues that are currently happening in the case so that those parents can really engage and move forward. Probably the best thing about dependency mediation is that it humanizes people. I don't know what it feels like to be a parent, standing up in that courtroom and hearing those things. I don't know what it feels like to be a social worker. Having had to remove these kids and face some very wrathful or unhappy or unstable parents. This is a really, really hard area of the law, and I admire all of you who can do this day in and day out. That was one of the things I really didn't care for about being a court master is it's really challenging to read case after case after case of what's happening to these kids. And for a lot of people, it's a case, it's something on paper. But when you're able to sit down at a table with somebody and get to know them a little bit better and understand them a little bit better and step into their shoes for a little bit, it's a really humanizing experience. It's really something we should be doing in all areas of conflict in our life, is sitting down face to face and having that conversation. And the result is that relationships build. That's how engagement happens. Either at the beginning stage, that relationship between the parent and the social worker can start building, or at the end. I've done mediations. I'm sure you all have had plenty of situations where the parents have never met the prospective adoptive parents. It's not the foster parents. It's a new set of folks. And that ability for them to be able to meet them and kind of get to know them a little bit makes a world of difference. They start building that relationship, which means they may be more likely to meet the terms of the post-adopt and have some contact or some information on their children as they grow, or some ability to maybe reach out to them. So really what we're trying to do as mediators is get everybody to look at things from a little bit of a different angle. Everybody who comes to the mediation table is stuck in a position, and our job is to try and figure out how do we move beyond that, how do we get unstuck, and sometimes being able to see things from a different angle is really where we get that movement. So it takes communication from poor to open, empathy. The idea is to try and get folks to stand in each other's shoes for a little bit. So they're coming in looking just at, I'm looking at myself or them. And we're hoping people can move more to a we and us. That's what makes this collaborative. Issues go from positions, here's what I want, here's what I'm advocating in court, to here's what I really need. Here's how we can make this happen. Choices. Once you're able to get people past positions and start looking at, well, what is it you really need out of this? It can open up the door for a lot of options. So there's no way for us to predict as mediators what options are ever going to come out of a session because they really happen through the process. And we're surprised all the time at, oh my gosh, who knew this would be an option? Who knew this was really what the parties needed? So all of a sudden, and I also can't tell you, I'm sure you guys get it all the time, people walk in the door and say, this case is never going to resolve. We're like, yeah, we've heard that, If we had $10 for every time somebody walked in and said this isn't going to resolve, and they walk out the door later having resolved it, we'd be rich mediators. That's why we're all trained and have a big toolkit. Is there really are ways to get people unstuck, and the most unresolvable cases, amazingly, can be resolved. And it's because we take those choices from the limited of we can only do A or B to hopefully a whole alphabet where there are many choices. And we've talked already about taking time from where they're stuck in the past to what does the future look like. And finally, we're hopefully taking conflict from negative to positive. I always do an exercise when I teach 40-hour mediation classes. I thought about doing it today, and I didn't, but our culture looks at conflict in a very negative way. If you think about the word conflict, what kind of words does it usually bring to your mind? It's fine. What else? Speak louder.
An argument.
Argument.
Disagreement.
Anger.
Fight.
Yeah, resentment, hate, frustration, stress. Those are where our minds go every time we hear conflict. We don't think of words like healing or opportunity or chance to change. The way our culture views it is very negative, but conflict can be very positive. And when you really think about it, it's conflict that leads to change. It's examining, what's not working, what you're disagreeing over, and understanding each other better and finding a way all right, but we can actually resolve it this way, and suddenly it becomes positive, right? I mean, think about the last argument you have with a loved one. You're in there like, don't like, but when you guys can fix it and figure it out and move forward, all of a sudden, your load has been lightened. So we like to help folks take a different spin on conflict and realize this can be a really great way to move forward in a positive manner. Okay, so I alluded a little bit to kind of what's been going on in the state and studies we've done. So dependency mediation started in the 2nd Judicial District, that's Reno, Washoe County, in 2011. Through this March, we've mediated 338 cases up there. We mediated all stages. So the way our program has worked, when parents come in once the petition has been filed, if they deny the petition, automatically goes to mediation. Same thing at the TPR stage. If they deny the TPR, automatically gets set for mediation. And then some of the in-between things get set. And we'll talk about kind of what those things might be, maybe a placement or something like that. If there's some kind of objection filed to something, it gets sent to mediation. This is the model, as I said, that we're hoping to adopt here. If I had to pick, I prefer mediations at the petition stage just because it's the beginning of the case. And there's still a lot of hope there, and there's still a lot of opportunity there, and there's a chance for those parents to engage in their case plans and get their lives turned around and get those children back. So it's really one of my favorite areas to mediate because of that. So our resolution rate over these years, is plus or minus about 75%. So 3/4 of the cases that go to mediation resolve. That has big impact on you guys and your calendars. It means a lot fewer hearings, trials, things like that, which makes a big difference. I know you are all, you have huge calendars and are working very hard. I'm not going to say overworked because I don't know. So when operating in this program and you're thinking, well, why do they do things this way? It came out of the second. We have had our share of bumps in the road up there and had to work through how things are done. And that's really what we used as the model for the whole state. It doesn't mean that we can't tweak things, in every jurisdiction. We absolutely can. We want to make it work everywhere. But this is our pilot program, and this is where it all started. So we've been able to have some studies done. This is the worst acronym in the world. NCJFCJ. It's the National Council of Juvenile and Family Court Judges. They are an organization that happens to be based in Reno, but they do all kinds of work everywhere in juvenile justice. They have come in and looked at the second JD's program and done some evaluations and had some pretty profound findings. Their findings were that mediation improves the outcomes for children because mediated cases are more likely to result in reunification. So this really does make a difference. Kind of a surprising finding we didn't expect. Mediation resulted in increased participation by fathers in their cases. I think that, maybe mothers are more likely to see through the case, to participate. But if fathers can get engaged in mediation at the outset, then they're a lot more likely to work that case plan. So that was a nice finding we didn't expect. Parents do feel it's a forum where they can speak. More court hearings are vacated. As you can imagine, if we've got a 75% resolution rate, then lots of hearings are going to be vacated. But it's not just that immediate hearing. It may be hearings throughout the whole case, because once people find a model, a framework to resolve dispute, sometimes they can go back to that model or that relationship that they've built, and so less disputes happen along the way. And they have found that it does create those cooperative relationships.
I think one of the concerns that was raised when we had our pilot program down here was, the time investment by the attorneys. I think the real important thing is you can put the 2 hours in or the 3 hours in at the mediation at the front end, and that can save you hundreds of hours at the back end, because you may not even get the TPR, because you may get access reunification. You don't have to adjudicate the petition, because we did it at the petition stage when we did it, to resolve the petition language. So it is time up at the front end, but if it comes up there and with the number of recordings might be vacated in the long term, it will save you
Absolutely.
a significant amount of time. That was the concern, because at the beginning we said, well, I'm real busy, it's tough to put the 2 hours in, because you really can't see how much you're really saving until you've done it a couple of times. But I think the real key is if you put that time at the front end and you do it the right way, it can, not all cases will resolve, but it really saves you a lot of time and a lot of conflict. I think the thing about relationships too, it helps you build relationships with the other attorneys. We're pretty good here because we kind of know everybody, in the tracks on that, but it really builds up that relationship where you feel you can call that attorney, and talk turkey with them like that too. So I think it not only builds relationship with the parents and the caseworkers and everybody, really builds it among the attorneys where they feel that they can really talk and be turkey and not worry that they're going to twist that on them at court or things like that. So, and I think the relationship is the real key. It's the whole department, it's all about building relationships, foster parents with the parents. That's our quality parenting initiative. It's all about relationships, building relationship with the courts, building relationships with those families. So I think the relationships is the issue, but it's the time. And I know with the numbers it shows at the time at the front end, you come back double or triple saving time in the long term with the amount of hours you put in.
And I know that's hard to see. It is hard to see because you're thinking, I got to take my whole morning and my whole afternoon to go to this mediation. But it absolutely, and the studies have backed it up, because those cases are resolving, it's a ton of time. I mean, when you think about what it takes for some of these TPR trials, I don't know, I know you guys are different in how long, I don't know how long you get, but they can go on for a while up in Washoe County, and that's a lot of time, prep, subpoenaing, all of that you don't have to do. So one of our tech problems we discovered this morning is my embedded videos don't work. But I do have a video, yay, it's actually a really long one. One of the wonderful things about receiving grant funds is you get to do kind of pet projects, things that you really want to do. So one of the first things we did when we got our grant money was to create a video. I took some deputy DA, parents' attorneys, our program director in the second JD, and we created a video to try to bring home to people what happens in dependency mediation, why is it meaningful, how does it work, and we put together this video. So it's about 20 minutes. You could probably get some popcorn and stuff. But let's see, I gotta get out of this. And so the nice thing is, if you watch this video, there's obviously 20 minutes, there's a lot of content. If you want to watch it again, or maybe it's something that you think would be helpful to show to clients or others, it's on YouTube. So all you have to do is type in Nevada Dependency Mediation. It will come right up, and you can watch it as many times as you'd like.
$3,500, 644 days, 75%. What do these numbers mean for Nevada's children? There are 3,500 children currently in foster care. These children are in care for an average of 644 days. 75% of the children in Nevada foster care are under the age of 9. When children are removed for abuse and neglect, it is traumatic, confusing, and overwhelming for the entire family. The courtroom feels foreign and adversarial, but there is an alternative to the courtroom, a way to help families work with the dependency process: mediation. Mediation offers a collaborative approach to dependency cases, allowing them to move forward quickly without having to go to trial. The environment in mediation differs greatly from that of the courtroom.
Mediation is a tool increasingly used by courts to resolve cases early and effectively.
The population of litigants that we have in our foster care cases is often very disadvantaged in terms of education and a lot of other barriers, and the courtroom is a frightening place. It's an intimidating place. It's a place when the parent walks in, everyone else seems to know who everyone else is and why they're there and what they are to do. And they are inserted into that environment at a time of total crisis and fear. Their children have been removed from them. Mediation could not be more different. It is structured to be relaxed and welcoming, to encourage their voice. In the courtroom process, there are all kinds of rules of which the litigants are unaware. In mediation, the rules are basically human civility, that we let people have turns at speaking and we don't interrupt one another there. It's an experience that is not foreign and not frightening. It's hard in a courtroom process for a judge to understand what a litigant wants most.
Dependency hearings are really hard for parents. They're quick, it's a foreign place, and lawyers are often talking on behalf of the parents. I think parents kind of lose their voice in that process. They don't get to just stand up in court and say, "Your Honor, let me tell you what happened here. Here's everything that's important to me." But mediation, it really is that opportunity. They can sit down with the social workers, with the district attorney, CASAs, whoever's involved in the case, and really share their perspective. And they can also listen to this perspective of others. That's just something that you can't get in the courtroom that mediation really offers.
Mediation allows everyone involved in the case, parents, social workers, attorneys, CASAs, and sometimes the children themselves, to meet in a safe, confidential environment to discuss the case and find ways to resolve it.
Another important aspect of mediation is that it allows both sides to actually see and hear from the parent and from the district attorney, and it allows them to come face to face in not as hostile of an environment as a trial would. And so I think what's important is that for my parents, having the DA and the social workers actually hear their stories and hear what they've gone through and hear what they're going through is a really important aspect of humanizing the client. And so I think that mediation offers that ability.
Because everyone in mediation signs a confidentiality agreement, it opens the lines of communication.
Mediation is also important with regard to parents being able to be open and honest, because when we enter that mediation room, everybody's signing a confidentiality agreement. And after that's signed, I do think parents think they can be very open with what's going on. In mediation, things remain confidential, and so they are able to say, yeah, that happened, but this allegation's wrong, and here's why it's wrong. This word's wrong, or the name's wrong, or the amount of beer cans you found in my house was wrong. And so they're more likely to look at the allegations in the petition and be very open with what's true and what's not. Because otherwise, if we don't have that forum, they're much more likely to stay quiet until the evidentiary hearing, because they don't know what it's okay to say and what it's not okay to say.
Mediation also encourages options for resolution beyond what a court could order.
If you have a good mediator, a collaborative relationship in that room at that moment to try and prioritize the strengths and minimize the vulnerabilities of the family, then you really have the opportunity to explore different and unconceived alternatives to what the menu is in the courtroom.
The mediation process allows parties to build relationships and find their own solutions, which helps parents become more engaged in their case.
Mediation humanizes everyone. Parents can sit across the room from me and also realize I'm a human. I'm not just the DA who's trying to take their children away from them. I'm a human being who understands and empathizes with their situation as well. In a recent mediation, I sat across from a mother and I told her, I don't want to take any more of your children from you. And she responded that I believe you, and that's the first time I've ever believed a DA that's told me that.
So after they engage in the process, they tend to get more engaged in their case, and whether that's fulfilling their case plan, going to individual counseling, or doing a substance abuse evaluation, it's my opinion that after mediation, they feel more comfortable in doing that, and they feel more comfortable around their social workers, and they see the process not as adversarial as the process when it began, but more as a teamwork to help them get their children back, which is the whole goal of dependency case.
We had one case where a dad was continuing to smoke methamphetamine, and the DA just didn't understand it. And he said, "Did you ever smoke cigarettes?" And she said, "Yes." And he said, "Do you still want one?" And she said, "Yes." And he said, "You got it." And the DA sat through that. That would never happen in a courtroom. And he felt like he had gotten a bit of human-to-human interaction as opposed to a judgment on paper.
Mediation can change the trajectory of a case. Disengaged parents become engaged parents. They develop trust with social workers, they understand the system better, and they can start working their case plans and really focus on what's important, which is reunifying with their kids.
Dependency mediation takes place at any time in the case. It's most commonly used at the petition, placement, and TPR stages. At the petition stage, mediation allows parents to get past issues surrounding the removal and move forward with their case.
One of the benefits of mediation is a chance to lay the groundwork for a relationship. Especially when we're talking about petitions, there's a relationship that's being formed between the social worker and the client. They're going to have to work together for 3 months, 6 months, 12 months, 18 months, and you're setting a different tone than has been set with the removal.
I remember one case I had at the petition stage. The children were removed because the father wasn't watching them closely enough at a really crucial time, and something bad happened to the kids. So the petition said that when this event occurred, the father was asleep. When father came to mediation, he was adamant that he wasn't asleep, he was in the shower. So the DA agreed to change that part of the petition to say that he was in the shower, and with that, Dad submitted to it. It wasn't material whether Dad was asleep, whether he was in the shower, but for the father, that was incredibly important. So once he was allowed to put that out there, the mediation really helped him move forward.
Client that had come into the office, and we had talked about the case extensively, and through it all, she wasn't willing to submit, and she wanted to take this to trial. And so I looked at mediation as a form of allowing her an opportunity to hear what the other side had to say. And I was hopeful that we would get it resolved, but I wasn't confident that we would. And throughout the course of mediation, it was about, I would say, an hour into it, she finally noticed the issues with her case, and we were able to resolve it. And again, she felt, I think, much more relieved and much more heard than she would have if we would have gone to trial, put her on the stand, and she would have had to testify. So I thought that was a good story for her.
Because mediation is a non-adversarial environment for the parents, we resolve petitions. We're able to remove or strike some allegations or change words and submit stipulations and orders as opposed to going to a full-blown trial.
At the placement and TPR stage, mediation can create a meaningful dialogue that helps move children to permanency faster.
One case that I will never forget took place between two sets of grandparents. On one side of the table, I had maternal grandparents whose daughter had been murdered. On the other side of the table, I had paternal grandparents whose son was convicted of murdering her. I can't imagine what it took for those grandparents to be able to sit at a table across from one another, but they were willing to do it because of their grandkids. They knew how important it was to find some kind of resolution of who was going to raise these kids and where they were going to be, and they were able to work it out. Those grandparents have kept in touch. This case happened several years ago. They still talk with some of the people involved in the case. The grandkids are thriving. They have relationships with both grandparents. Without mediation, I don't think that conversation ever would have taken place.
In the alternative, on something like a termination petition, there's a chance that you're going to have the prospective adoptive family with the biological family, the family of origin, and a mediation that is well run, that is supported, where my client doesn't feel like the table is loaded against him or her, sets the foundation for a relationship that can be beneficial for my client, for the social worker or prospective adoptive family, and most importantly for the child.
I've had some very, very beautiful mediations where the parents finally decided, after hearing from prospective adoptive parents, seeing how much everyone in the room loved the child or children. I've had parents decide to relinquish based on just coming to the table and meeting and talking about what everyone's there to talk about, and that's children.
I was a mediator in a termination of parental rights case. So when we came into mediation, of course, it wasn't immediate magic. There had to be some warming up and some talking and some invitations to her to let us know what she was thinking. And she told us that she understood she was going to lose. And so that opened the opportunity to talk about what could we create that would fill the need she was trying to fill when she wasn't expecting to win. And we had the prospective adoptive parent, who was the foster parent, in the waiting room, and she ultimately joined us. And it took several hours, but over those several hours, the two of them spoke to one another. They had never really spoken to one another other than for visits before. And by the end of it, it was clear from what the mother said that her biggest fear was that her daughter would not understand that she loved her, and think she had just abandoned her. And by talking to the adoptive mother, the prospective adoptive mother, I think she was reassured that the prospective adoptive mother intended to honor her role, never intended to pretend there hadn't been an adoption and that she was anything other than her adoptive mom. And at the conclusion, one of the most poignant interchanges I've ever seen happened. The birth mother, when I invited them all to say, is there any unfinished business? Is there anything else that will help you? The birth mother asked the adoptive mother, and said, I have a box of the baby's mementos, her early pictures. I'd like to share it with you. If she sees these things as she grows, she will know I wanted her to have them. I will feel she will know I loved her if she has these tangible things. And of course, virtually everyone in the room dissolved in tears. But no court experience can ever allow that. It's not structured in any way that would ever allow that. Mediation allowed us to understand what she really needed. The court process would have trampled on what she really needed and would never have gotten there.
Nevada now has a way to bring the mediation process to every judicial district in the state through the Juvenile Dependency Mediation Program. This program allows trained, neutral mediators to be assigned to dependency mediation cases statewide. The program is based on a model used by the 2nd Judicial District Court. Studies of this program have shown that mediation is an efficient and effective use of time.
The Administrative Office of the Courts contracted with the National Council of Juvenile and Family Court Judges to really ask the question, does mediation matter? And the result was that it does. And it does in some very profound ways. The National Council, in the first study that they did early in 2013, really looked at process as well as outcomes. And with respect to process, the Council found that participants and stakeholders felt that mediation was a wise use of time, that it resulted in agreement most of the time, and that it was time savings for them in preparation and time savings also for the court. The second study looked at outcomes. In that study, which was done in December of 2013, the question really was, does mediation result in different outcomes between mediated and non-mediated cases? And the answer for that was, yes, it does. The impact was that mediation resulted in cases reunifying more quickly than in non-mediated cases. And then the second finding, which is very significant, was that fathers who attended mediation were more likely to participate in subsequent court hearings. So you had two findings that were really noteworthy from this study. The enhanced likelihood of reunification in mediated cases, and secondly, improved parent engagement, specifically fathers.
So I think another important aspect is the time savings that both the public defender's office and the district attorney's office, as well as the court system. And the reason is, if you can resolve the petition via mediation, or if you can resolve any aspect of the case via mediation, then it allows you time saving so that you're not overly burdened with pursuing a case that can get resolved in another way. And because the court and the judicial system is as burdened as it is today, mediation is a critical component of this process, and I believe it should be utilized more.
Mediation makes a difference and enriches the process in dependency cases for all involved.
Since the inception of the program, we've made it a regular practice to survey participants as well as stakeholders at the conclusion of mediation. And the comments that parents give, the feedback provided by stakeholders really paints a picture that mediation has sometimes a significant impact in people's perceptions of the process. So parents, for example, report feeling heard, perhaps for the first time. They often report that they can raise issues in mediation that may be outside of a legal issue, but are important to them. So having a voice and being able to be part of the decision making is really important to parents. The DA has offered the perception that this gives parents a voice in the process. So I think that really describes what some of the benefits of mediation are to the participants in the process.
There's tons of research on ways that you can mediate in a way that is both advocacy and collaboration simultaneously. And I would advocate, as someone who has really found this beneficial for families, that if you have the ability to engage in mediation, look into it. It's interesting research, and it can only make you a better litigator to have more tools in your toolbox.
One of the things that we know about all courtroom proceedings is that process is paramount. That's been empirically shown in literature that people can have an adverse outcome in a courtroom, but how the process went matters. The ultimately best process for these family cases is not a courtroom at all. It's outside the courtroom. It's in alternative dispute resolution like mediation, where folks' voices can be heard. The same outcome achieved in mediation and the same outcome achieved through a court process can feel 1,000% different to the litigants. And we know that they accept it, they live with it, they follow it differently depending on how they feel about the process.
Anyone involved in the dependency process can ask the court to order mediation. The court will set the time and place for the mediation and send it to the program administrator to assign a mediator.
As the program administrator for the Juvenile Dependency Mediation Program, I'm so excited that we have this opportunity to bring this process statewide. It's an amazing thing to have the means to help children gain safety and stability in their lives.
But there are moments in mediation where magic happens.
With the Juvenile Dependency Mediation Program, Nevada has the chance to become a leader in the dependency process. We owe it to Nevada's children to use every tool available that helps them achieve the permanency they deserve.
More about that or is looking for hands-on experience. So shameless plug there.
No, it's a good plug. Because it is such a different role to shift from being an advocate in court to being a collaborator in mediation. So I think any tools you can find that can help you make that shift are really valuable. So we're going to dive in to the actual protocol of how we do things, what is within the confines of the program and what is not. Basically, this applies to all pre and post adjudication abuse and neglect cases. We have to be past the filing of the petition. We would love to go in there and mediate before children are removed. That would be a dream of mine, to be able to do that before they even hit the court system, but our grant funding does not allow that. So it has to be post-petition filing. So as you've heard maybe a gazillion times by now, we're looking at petition, placement, permanency plans, and including TPR. So what are we doing? What are we doing at petition mediations? Every once in a blue moon, we might actually be talking about jurisdiction. Much more often, though, we're really looking at the wording of the petition and the findings being sought. Kind of like you've heard in that video, the wording can make such a difference. And the way I look at it is the petition is a one-sided story, right? I mean, it is the story of based on what happened with social services removing these kids. It's that perspective. And that's the nature of the system. That's what it needs to be. But I think for a parent reading that petition, they're always going to have a different perspective. And what is always amazing to me is just the changing of a few words sometimes just makes all the difference in the world to a parent. Because finally, their story is a little bit represented in there. And our DAs are amazingly accommodating for this process because they've fully bought into it. So sometimes they may add a few words in a petition that maybe really don't belong in a petition, but represent the parent's story. And so it's kind of no harm, no foul if they can get engagement and submission to the petition by adding those few words or changing things around. They're absolutely willing to do it. Findings can be a little bit more challenging. One of the things, as I've said, I found in doing these mediations in different jurisdictions is there are different interpretations in these jurisdictions of how things work. But a lot of times for findings, it's all about the central registry. And the way they do it in Washoe County is only an abuse or neglect finding gets reported to the central registry. I don't know how you guys do it here. Other jurisdictions report everything. But it becomes important in those cases, depending on what the parent's line of work is. They may have a real worry of something going into the central registry. And so they're going to be looking in mediation to change it to what is viewed there as a lesser finding, unable to meet the children's basic needs or unavailability, something like that. And does that mean that the finding always gets changed in mediation? No. It really comes down to what is the parent looking for and what is social services looking for and willing to do. And sometimes it's not appropriate for them to change the finding. They're not going to do it. But we may be able to find a way to make it work. Sometimes just changing that wording and not even changing the finding is going to move it forward. Sometimes it will segue into, okay, what's the case plan look like? What services do the children need? What services do the parents need? When's visitation going to be? Things like that. That will really take all of the issues that have come up, bubbled up to the surface by the time mediation rolls around, and deal with them and talk them through and get an understanding of what works, what doesn't work. Sometimes we'll get super funky ones. And my best example of this one is a case that I did where the parents at the petition stage were ready to just go to TPR. Not a very usual scenario, but it was for the child involved. These were her adoptive parents. She had already gone through an entire removal and dependency case with her biological parents, and that had resulted in an adoption by these parents. And this child was, I think, about 16, and she contacted the social worker and made some allegations against the adoptive parent of some inappropriate sexual conduct. And so these adoptive parents just said, this is not going to work out. Very sad. But the mediation centered around the parents' attorneys were saying, look, let's just go straight to TPR. We don't need to go through the petition stage. They want to relinquish. Let's just go straight there. And DA's office was saying, I don't think we're going to have jurisdiction if we don't have a finding in the petition. And that's really what the mediation centered around, was a little bit more of a legalistic conversation than often happens. But the adoptive parents were very participatory in that. And we were able to kind of flesh it out and look at it and make it work. And that was also a case where a lesser finding was being sought by the adoptive parents, and the DA's office was willing to give that. And so it resolved. So sometimes you get super funky things like that, or cases You always get those cases nobody thinks are going to resolve. But just sitting down, walking through them, it's kind of an amazing process. So placement. Sometimes placement's not working out. We see this sometimes with older kids. Maybe they're running away, or it's just not happening, or it's about to blow. It can be a great time to come together with the foster parents, and sometimes the children. We'll talk about children being all involved in a little bit. Or sometimes there need to be choices. Is it going to be with the foster parents these children have been placed with? Now we've got a biological placement where ICPC's finally been approved. Who's that placement going to be? Sometimes that's at issue. Sometimes the parents are objecting to that placement. I had a really nice case a couple weeks ago where they were young children. The mother was a severe alcoholic, and these kids had been placed with her parents. And along the way, things got really bumpy, where kids were with grandparents. Grandparents separated, so just grandma had the kids, and her daughter, the mother of the kids, came knocking at the door. I'm destitute, I have no place to stay, please take me in. And so grandma took her back. Nobody told social services. Grandma was really having a challenging time with understanding her daughter's alcoholism, understanding what that did with the kids, where the boundaries should be. And so when social services found out those kids were, mom was back in grandma's household, they removed them. So we're maybe 9 months down the line. It's looking very much like, actually I think we were much further than 9 months down the line. We're way down the line. It's looking like TPR is going to be the option. And these grandparents now were back together again and desperately wanted to adopt these kids. They had, a huge, important relationship with them. And social services and DA's office were saying, not so fast. We are very doubtful here. We just don't know that you have a good understanding. And so we all sat down at the table. And this was one where the DA, deputy DA, was really, really active. It could have been the social worker. In this case, it happened to be her, and she asked the grandparents a lot of really important questions, about what have you learned along the way? This child may have fetal alcohol syndrome. What do you know about that? What do you do if you are the placement and your daughter comes knocking back at the door? And these grandparents were wonderful. They were really prepared and were able to genuinely demonstrate that they had learned a lot along the way. The grandma made a comment of, I now know that there's a big difference between binge drinking and alcoholism, and my daughter's an alcoholic. And our priority are these children. So we had this really wonderful session. When I had been orienting the parents, we'll talk about our process and how we orient parents, grandparents, before they go into the session. The grandpa had caught on to what was happening here, and he said, if I'm understanding you right, this could be a chance for us to get our grandkids back. No, I'm not going to commit to that. I said, I've seen a lot of things happen, and I think everything's open. This is a great time to talk about how it could look and what you would like to happen. And he was absolutely right. That's exactly what happened. By allowing the district attorney and the social workers to sit across, to kind of gauge their veracity, to understand kind of what their progression had been in understanding the alcoholism, to feel that assurance that their priority absolutely was these kids, and if the granddaughter came knocking back on the door, they weren't going to let her come back and live. That was it. Decision was made, and the placement was going to be moved back to the grandparents. So placement cases really can be so powerful and just demonstrates that exchange of information and that understanding. These were really good people who had some bumps along the way and really hadn't grasped what was fully going on. But months went by and they had evolved, and they just needed to be able to show that. So that's kind of, one little snapshot into what a placement case might look like. Permanency plans. Sometimes we're exploring the permanency plan has become TPR, and the parent's like, whoa, I'm starting to work my case plan. I want a concurrent permanency plan. Let's talk about it. And then we have the termination of parental rights. When we first started this program, I remember talking to some of the DDAs who I had worked with when I was still at that office and knew well, and they said, what are you guys talking about? How can we possibly mediate a TPR case? Some of you now have done that and have seen, oh wow, there are things to mediate. It's really going to depend on what's happening. Sometimes we actually are talking about reunification. Every once in a blue moon, we'll get to the TPR stage, and once we sit down at the table, those parents have started to engage. Maybe they finally have seen the light and have caught on. It doesn't mean that everything stops, and happy ending. But what it can mean in the mediation is, let's hold that in abeyance. We're going to give you another shot because you're really starting to work this case. We're going to hold it in abeyance for 3 months, 6 months, and let you re-engage with that case plan, and let's see if you can do it. So occasionally we are mediating something like that. A lot of times we're mediating things like relinquishment. Maybe it's a case where, the children often are more adoptable if they're free for adoption. And sometimes being able to help parents understand that. And obviously parents' counsel is really important in that, in helping your client understand that oftentimes at this stage, reunification is not likely, and winning at a TPR case is not likely, and kind of allowing them to step back and look at the bigger picture of what's best for their children. That's a lot of what happens in those mediations. And many times we're looking at post-adoption contact agreements. So I just kind of want to give you the program's perspective on these cases, and then I really would like to have some discussion on it because I know there have been some bumps in the road on these post-adopt cases, and I'm hoping we can walk through that. So from a program perspective, what we're doing here is, well, let me explain the difference a little bit. So in Washoe County, all of our agreements are written. We do not have the ability to go to the court after the mediation and go on the record. So it's a different model than what's being used here. It's a better model to be able to go on the record because it allows the judge or the master the ability to canvass parents to make sure there's true understanding and that the agreement is voluntary. But we don't have that in Washoe County. Same point though. The mediator's there to record the points of agreement. If we're in Washoe County, we're doing that in a written agreement that everybody signs and is co-signed by the court. If it's here, it means mediator taking note of what the agreement is and everybody going on the record and putting those terms on. It does not mean the mediator is drafting the post-adoptive contact agreement. From a program standpoint, that really crosses the line between mediator and an attorney. And plus, you all know what post-adopt agreements look like. They should be thorough. They should be well thought out. It's not something that really is going to happen in a mediation. It also means relinquishments generally are not going to take place at the mediation table. I've maybe 2 out of the however many I've done where there was an actual relinquishment. Lots of reasons, but one of them is it's overwhelming on these parents. It's already overwhelming to sit through this mediation and make those big decisions to relinquish or to talk about what this post-adopt is going to look like. For everybody to swoop in and take the relinquishments right there, I think it's too much to ask. But I know there have been some bumps with post-adoption agreements and terms, and so I kind of wanted to throw it out to you and get a better understanding of what's not working about this, or what is working.
The feedback I got at the Inspire meeting was that there's some feelings that the prospective adopted parents really weren't part of the open adoption agreement. It was felt that the parents' attorneys, whoever was kind of preparing it, was kind of ramming it down their throats now. And I don't know if that's true or not, but that was one representation from one of the parents' attorneys that, and she represented the parents, the foster parents. She was actually advocating for attorneys for foster parents. But that was a concern that with those post-adopted, that the prospective foster parents really weren't engaged in making it. It was kind of saying, take it or leave it. Or we go to TPR, things like that. So I don't know if the other people have that agreement, but that's was brought up at the bench bar meeting.
That was brought up at the bench bar meeting by someone who hasn't done mediation.
Yeah.
I do want to say. So I have done a number of mediations, and I was really excited that we were going to have a written document, because that's how it was presented, and very disappointed that we don't. So let's do it. And even if it is the defense counsel coming in with their own mini office like I do, and doing the open adoption agreement right there, even if we don't get the relinquishment, or even doing a stipulation in order to extend out the TPR trial date or status check, because my mediations have not been only termination of parental rights or relinquishment. We have gotten extra time for some parents. We have had reunifications, but not coming out of there with something written. I don't care what people say on the record. I don't see the judges holding parents' feet to the fire, and it's unfair to us to spend 3-4 hours and negotiating with foster parents and then have them turn.
If you come in and put an agreement on my record, you're going to do it. I mean, flat. I don't know who's taking a position otherwise, but you make a record, I'm going to hold you to it. It's going to be binding. So.
My other feedback is not about the actual contracts, but it's every time we do a mediation, it feels like we are an annoying force coming into a courtroom, having to scoot in to get something on the record, and some hearing masters or judges do that okay, but their staff doesn't. What do you mean? What do you mean I have to put this on? And what's the case number? Are you serious? We have 20 other cases and you're going to come in here. So we need to get that glitch worked out. The mediator should be able to contact a certain contact person, and that gets put on within 30 minutes or an hour, and it not feel like everybody who just emoted all this energy. And I mean, it's so packed with emotion. You're drained at the end of a mediation, and now you have to feel like an imposition. That's ridiculous.
I think that the judge has always been willing to come back on the bench to put it on the record. I think one thing I have found though with some of the mediations is at that moment the parent is ready to make the decision, but then later the whole process of going through getting transportation to come down to actually relinquish, like we have it worked out, and then when they have to follow through on a later date, they just can't do it. And so then they're after working to get a resolution and an open adoption agreement and the terms defined, then the parent doesn't show to go through the process and the rights end up terminated.
Yeah, I mean, there's a lot of challenges with trying to find a model that works, that's not overwhelming, and I think this is a really good place to try and fix what's not working. So let's start back with the going in and going on the record. Judge Sullivan, do you want to speak to that?
That's an easy fix. You let me know. You give me a name of somebody that gave you a hard time, and let me deal with. The employees work to 5 o'clock. They don't work to 4:30, and if some of them do, if they're staggered 4:30, we just need to know that we got a mediation going on, and we need a judge to be on duty. We'll have one the judge, one the hearing master. It should be the hearing master, the judge whose case it is, should be there to put it on the record, know the mediation's going on, but if there's an issue, we'll have someone assigned on that to be, like we do now with objections, we have a judge on duty to sign those. If there's some staff that thinks it's in position, we'll deal with that and give them an imposition themselves, because they're county employees. They're servants of the public, and they should accommodate everyone. I don't care if it's 4:45, they work to 5 o'clock. If they need to stay overtime, they need to stay overtime, and that's the issue. I know we had one that they couldn't find someone, it was like 4:45. The person had left at 4:30, said, we gotta have coverage at 5 o'clock, so we have adjusted that. But just let them know, let Master Gibson know on that, that's an issue. Just bring it to my attention, and we'll make sure it gets resolved, because that's the first I heard that was an issue, other than one when they had some time getting it on the record late. Yeah, just
In my experience, at least the last one I did, we had an agreement, we went in to put it on the record, but we didn't put anything on the record other than to say we had an agreement. And then, right? Right, so all we said was, yeah, we have an agreement, and that was all we said, but none of the details of the agreement were ever put on the record.
And why not?
I don't,
We were imposing on somebody.
yeah, basically, and so it never got done. Then what happened was the devil, of course, is in the details.
Right.
We understood among ourselves what the big picture, of the agreement was, and then it actually went down and ultimately crumbled over things that were kind of like nitty-gritty details that nobody had even really thought were going to be issues, in the picture, and so it kind of ultimately fell apart. I mean, it never did happen, even though we reached an agreement. It ended up going to TPR anyway.
Right.
Does that
and
happen
that's-
more than in the one time?
I've only had two. Yeah, both times, in fact, the agreements were not put on the record. Both, I did two, and neither one, it was, the only thing that was put on the record was that we had an agreement.
Right, and that's not going to be helpful.
Well, that was my
It's not gonna be helpful.
I came away feeling it wasn't helpful.
Right, it absolutely, I mean, because we have to draft them, we are absolutely spending time at the end of the session saying, okay, what do you want me, council parties, what do you want me to type here? The same, I think the same discussion needs to happen. What are we going to put on the record? Because it's a little bit different. The mediator's not standing up putting it on the record. Council is. You guys are the ones putting it on the record. It needs to be exactly what you would want it to be in writing. Otherwise, it's not meaningful.
Well, absolutely, because that's what happened. Then there were disagreements. Oh, well, was it 1 hour visit? Was it 2 hours? What, whatever. So that's where it just kind of, and then it just dragged on while everybody tried to catch everybody to. The process was great. It just kind of got mucked
Just crumbled
up
in the end.
afterward. Yeah.
If you're doing a mediation on termination of rights and foster parents, why not have an open adoption agreement ready to go? That's what I've done in every case.
Here's where that's a challenge. Here's where it's a challenge. I think that can be a possibility, but first of all, there can't be an absolute expectation that there's going to be the time to do that, because I've done a lot of these mediations. Sometimes the parents are there. I mean, when we're doing a TPR mediation, we are meeting the parents where they are, meaning they might be walking in the room, and where they are at that moment is, I want to take this to trial. So we need to take time in that session to walk them through what does a trial look like. That's when I absolutely 100% need deputy DAs there. I need you to, very dispassionately walk through, this is what it looks like. It can take 75% of your mediation for them to hear that, to understand it, to start turning and go, okay, I think I'm going to voluntarily relinquish. And so you have 25% of your time to walk through what are those terms going to be. There's just no way you have time, if your mediation happens like that, to draft a full and complete post-adopt agreement, which is why we put very specific terms into our agreements. Sometimes parents walk in and they are ready, and that could be a time where it may work. It's got to be somebody else. It can't be the mediator. One of the things we are going to do is buy a computer, a laptop, and a printer for the mediators to be able to use. So that I think it could create several options there. One option is somebody could bring a post-adopt on a flash drive. If it's the mediation that goes that way, then whoever is that author can create the post-adopt right there. We've definitely done that with occasionally in the second JD. We do it a lot at the petition stage where they want to draft a stip in order right there. I'm fine with that. I'm not drafting it as the mediator. But it also, maybe there will be a preference. Maybe some of you would prefer, and we haven't really run this by mediators, but maybe some of you would prefer to walk out with a written mediation agreement countersigned by the judge rather than going on the record. I don't see any reason why it couldn't be done either way, because there may be more comfort in having that written agreement. What do you?
Yeah, if we have a computer and a printer, I couldn't imagine prior to doing this, having a mediation without a computer and a printer right there to get signatures on any kind of mediation that I've been involved in, whether as an advocate or as a mediator.
Right.
So that's a huge step right there.
We'll get it to you. You want a computer and thing?
Right.
I got a commitment, you'll have it.
I would always have a memorandum of understanding and have some basic things in a template, regardless. But if you have attorneys there who have a thumb drive and want to draft, with their readings and their headings and get it done, I think it's fabulous. I think it's a great idea.
Yeah, as long as there's time. I mean, I'm protective of my mediators as well. It's not like they get paid, lots of big bucks. If we're talking 5-6 hours because this post-adopt needs to happen, that's going to be problematic for me from a program standpoint. So I just don't want you to have the expectation that every time it's going to happen, because it just depends on where the parents are. But I want to be able to create the opportunity in a reasonable way for it to happen. Kathy?
Right, and so also kind of going back on putting it on the record, maybe what we need, I heard Hearing Master Gibson say, if you put it on those terms on the record, I'm going to hold them to it.
Yeah.
So I think we need to know that all the hearing masters, each of the hearing masters is going to do that, because the attorneys are skeptical. And I know a couple of these cases have fallen apart, one of yours and one of Jennifer's, of mediations that I've done. But I've always insisted that you guys put those terms on the records, and you guys say, oh, no, we just agree they're going to relinquish, and we agree there's an open adoption agreement. Oh, you have to put those terms on the record, and then they'll hold them to it.
Yeah, I think every one that I've come down for, we put terms on the record, so,
I did one time in here,
yeah, if they want to write them down, that's fine with me too. Either one works for me. You guys want to walk out with the writing, I'll sign it. You want to put it on the record, I'll come down, we'll put it on the record.
Right.
And I know that Holly's covered one for me. I know I've covered one for her or for John. If I needed to, if for some reason there was a time constraint and the hearing master that was on that day needed to leave, we talk to each other. We'll cover for each other.
And then that's another issue. I know Marie was talking about that it's frustrating sometimes finding someone that we could go into the court and get it on the record. That's because on Wednesdays in Hearing Master Dormheim's, he's not here in the afternoon on Wednesdays, so it has been a bit of an issue on a Wednesday.
Won't be an issue. I'm here. Just let me know.
Who's
Make someone there.
Right, so
I'm
I've
always
had
here.
cases where we have gone into your, Hearing Master
Come on.
Lois has been really accommodating going into her court. She's fit them in between hearings. And so it's had, I don't feel like they think it's an annoyance. They realize it's just going to take a couple of minutes, and I know she's been really willing to do it.
Yeah,
Well, it's not the judicial officer.
So the staff, okay, yeah.
You're doing your mediations in the courtroom. You have a printer and a computer there. All you need is a
No
password to
access.
get access. Well, yeah, so we can get that. We didn't know that.
That's an IT issue.
Yeah, we fixed that. I said we didn't realize that was an issue. Number one, when we did in the past, we did have the agreements. The problem you got with enforcement, they say they do an open adoption and they're going to relinquish later, and they don't relinquish. And I'm not going to sit there and say, you already relinquished. You got a problem constitutionally if they go up Supreme Court. I'm going to be a couple saying, well, you said you were going to do it. You signed the open adoption, you relinquished. Now you don't show up to relinquish, which is the whole process that they sit down there. I don't know if it's to say, well, you relinquished.
Let's
so
put
it's
it
an issue.
on the record with the prove up.
Yeah, that's the issue. Then you do the
Take
prove
a
up where you
verbal
got the grounds that if you don't.
Yeah, take a prove up
And then
in
hold
case
it in
they don't
abeyance.
I
relinquish.
did mediation in a different jurisdiction for many years, and we had somebody there ready to take relinquishments. It was part of the deal.
That's the problem you have.
That's what we should be doing.
Because if you do it after the fact, it's a tough
Right.
constitution. So you said you're going to do it, now I'm going to do it.
Right.
But we did prove ups and held them in abeyance, the same thing. So there's ways you can do that, but you're right, just enforcing after the fact, they don't show up to relinquish, said, well, too bad, you said you were going to do it.
Yep.
Now I'm doing it for you. No, you're really terminating the parental rights, or you need to do it as a termination for rights or have them relinquished at that time where you have it a done deal, because some won't show up, they mean well, but they don't show up to the relinquishment because they might go missing in action, we end up doing a prove up after the fact.
I think the only ones we had scuttle was we had one particular worker that riled the parties up after they had agreed to it, and then when they expressed a little emotion about giving up their children, the worker said, "Well, I'm not doing it," and walked out. And that's the only time we've had. That's the only time we've had it scuttled, and the DA's been good to try to work around that for me. We had another one coming up, and we knew that worker might be the one, and we were like, "Whoa, no, not that worker for these people, not that worker. This dad is an intimidating guy. Just he looks intimidating, and so the worker's going to say I'm intimidating. And this thing's going to go south. So we picked somebody else. You know, I mean,
It's happened 3-4 times, the same worker.
Same worker, so.
We had a mom that was shedding tears and she walked out too.
Yeah, we.
She said, I'm not gonna take her, really.
We know what the issue is with that particular. That's not a mediation problem, that's not a.
Maybe she's in the wrong line of work.
That's
no emotion.
That's knowing your personnel and making sure you got the right people there type of thing,
I have a
but.
question, because if you were to go on the record and put all the terms on there, and then the foster parents, like in mine, then told us to kick rocks after we drafted the agreement, how are you gonna hold them accountable?
Were they part of the mediation?
Yeah.
Well, they're gonna come in too. I'll swear them.
I mean,
I'm serious, I'll swear them in. I'll say you agreed to this and I'll get it on the
Like,
record.
how are we gonna hold, if they say, no, I'm not doing it now? Then you have to hold them
That's why I'll go
accountable.
on the record and I'll swear them in, and they're gonna have to do it now. It's gonna be a binding agreement. It's a post-adoptive, it's a contract. It's a post-adoptive agreement. I'm gonna swear them, put it on the record. There you go. Show me a Supreme Court that's not gonna hold that up.
Well, their argument's gonna be, everybody else in that room had an attorney, and I walked in and had all these attorneys going, you need to sign this agreement so we can get this done. I mean.
I'll canvass them to see if they were coerced. Just like I do with anybody that doesn't know contest.
It's not the attorneys telling them to sign it. During the mediation, they were offering terms.
Oh,
We started off by saying, what will you offer? And they put it out, and then when we came to sign the agreement, they said, no, we're not gonna do it, and we didn't offer anything. And I was like, well, actually, I started off by saying, what will you offer? But
I'll put a mini evidentiary hearing on right there. I'm not gonna have my time wasted. I mean, if I can use that time for a TPR trial and just get it done, I'm gonna do that. So if I'm gonna free up my calendar for a mediation to take place, and you guys come to an agreement, let's put it on the record. If you feel, counsel can let me know if they think that it might go sideways for one reason or another, and I'll determine what evidence I need to take, and I'll do it.
Does that violate the confidentiality of mediation? I don't know.
Well, if they made an offer, I mean, given the terms of what they agreed to.
It's a very good question. It might be a better model to do the written agreement.
I'm just
because
saying,
we are,
until you get it figured out, that's what I'm willing to do.
yeah, we are so careful to not disclose to the court only the terms of agreement, but not how it was reached and not what happened.
And not what didn't work.
But the idea, our job as mediators always is to make sure that people don't feel coerced into giving an agreement. That's the first thing I tell prospective adoptive parents is you don't have to agree to anything. You're going to be the parents of this child. You need to determine what's workable for you, what's not workable, what you can or you can't do. It's kind of a hot button right now, though, because I've heard some murmurings in the second JD about issues outside of mediation, but that some prospective adoptive parents are feeling extreme pressure by some social workers to agree to terms, or we're going to place the kids elsewhere, things like that. So all of these things are a work in progress. On the relinquishment piece, I guess all I would say is if that becomes the practice, as long as that's done when the mediation is finished and my mediators are excused, that's a different issue. That becomes your process. I just don't want it to become our process. So if we can draw that line, I'm fine with that.
Maybe there's a different experience, but the only time when I've seen the department willing to do
I'm sorry, can
a
you speak up?
mediation, the only time when I've seen the department willing to do a mediation is when they think that they're going to talk our clients into relinquishing. And so I'm seeing one parent's attorney shaking their head, but it's interesting because that's not, in those situations, and this has been in different courtrooms, but the clients are like, no, why should we do that? I mean, they feel like they're the only one that's going to be in a position of having to give anything. That the department is absolutely against any type of reunification, so the mediation is basically you come in so we can force you to give up, and in those cases, the clients have declined.
So the idea and the way mediation should go in that circumstance is not for social services to say, you come in so we can tell you like it is. But it can often serve, I mean, you all know there are a lot of TPR cases that are not going to be winnable if you're a parents' counsel. You know what the odds are, and you know this is not going to be winnable. But there are advantages to relinquishing rather than having your rights terminated. There are presumptions in place. There's the opportunity for a post-adoptive contact agreement. So sometimes mediations in that circumstance, they're not about ramming something down the parent's throat, but they're about making sure the parents understand the options, making sure they understand the difference between a relinquishment and a termination, making sure they understand that if it goes to termination, there very well may be no post-adopt contact agreement. It's about trying to have a discussion, and hopefully, if you've got a department on the warpath on that, hopefully it's tempered by the mediators trying to make it more of a conversation.
No, I agree. In those circumstances where you know that the client's not going to win, the mediation is helpful to get them to have a more gentle process of having other people explain to them. So they're hearing it from different parties about the benefit. But I'm talking about cases where you have a good position, the parent has a good position as well, and the department's just like, well, we'll have the mediation if they're going to talk about relinquishing, but otherwise we're not having the mediation.
Well, they don't get to make the call. They're ordered to mediation. And it is not, it's not unusual for me to have a mediation that starts with the department on a very hard line position. But I have also watched that hard line position shift. You have to do enough of them to really get a feel for what the process can bring. And it also very much depends on who you have sitting at the table. I mean, I can walk in and go, oh, I have that social worker today. This is going to be tough. Or, oh, I have this social worker who's really great at engaging. This is going to be better. You never know what you're going to have when you walk in the door, and there's no way possible to categorize how it's going to happen. There's no way to categorize, well, if the clients have a good position, there's never going to be an agreement because the department's not going to come in and change their mind. I've seen it happen. It can happen. So you just deal with what you've got, and the mediator's there to create the best process possible. Does it guarantee agreement? No. No, but it certainly results in agreement a lot of that time. So my hope is, the more that you see, there will be more where you do see some shifts that you didn't think would happen, because they will come. I've seen it happen too many times.
It seems to me one of the advantages of coming out with a written agreement is that you're not limited in your venue. Part of it is, I think that, all the mediations I did, and I was a mediator in Hawaii, and we never did a mediation in the courtroom. Just because of the psychological image of the courtroom, you're sitting there in a circle with the bench behind you.
Right.
But if you're not coming out with a written agreement and you need to go right down and find a judge, that's field expedient. But if you're actually coming out with a written agreement, you're not limited to a courtroom venue. You can meet in one of the attorney's offices, you can meet in a conference room, and I'm really, even looking at parents, if I were a parent, I would not want to be having a mediation in the courtroom.
You know, that gets down to the weeds. We discussed that. The reason we had in the courtrooms because there's concerns about security and spaces. So to get it started, we said we had hearing masters that had a dark afternoon. That'd be a way just to get it started. But we talked about not having it in the court because of the things that's set. But there's issues with they wanted marshals present. They're trying to get that there. They said we couldn't use the conference room 319. People coming and going. There's security issues. So that's what happened. We said we'd be glad to have it somewhere else off-site for that reason, but we talked about that, but we can get to that. That was a concern we had, but to get it started, we looked at that for reasons on that, but those concerns were raised about getting a neutral site, and we can work on that, get a neutral site.
I understand if somebody's in custody, okay, that I understand,
sure.
but we have CFTs all the time, where, we have them at DFS, we have them here, we have them there, we have them in our office, and we're
That
not,
was your input,
security
the
is
people
not
we
an
had
issue.
there, they wanted security, they said security wasn't.
There have been some mediations that have been so, prior to the mediation, there were clients who said, in regards to having a marshal present, yeah, you better have.
Assault rifle.
Assault rifle too.
Well, those I
So,
get. If there's
so
TV, I
there
get
are-
that.
There are concerns sometimes about making sure that it's in a place where somebody's gone through a metal detector,
So we kind of got to get back to the presentation, and I understand. I mean, this is a work in progress. Is the courtroom space ideal? No. I mean, any mediator would go, no, I don't want to, I'm trying to get everybody away from the courtroom. So these are definitely things we can continue to explore. Is space written versus on the record?
It seems like it might be easy, though, when one comes up that you don't think you need a courtroom for, that the parties could stipulate to a neutral place to go to, somebody's office or whatever. I mean, the courtroom's available, but if all the parties want to do it elsewhere.
As long as that can be done without confusion. We've had our share of confusion over locations in this program, and so that's the key, because we can't always get hold of parents. So, but we've done that. I mean, in Carson, we've mediated there, and the courtroom, it sucks to mediate in their conference room. We've moved them to DCFS, and I've told Parents Council, if it's one where your clients really can't walk into DCFS, we'll move it. But if you think they're okay with it, this is a better venue. So we can play with things a little bit. We just have to make sure that it's not confusing. And this can be a continuing conversation. In the perfect world, we'd have a secure space with a metal detector that doesn't look anything like a courtroom.
I have a question. So the majority of cases dealing with termination of parental rights, you're doing a mediation, you're really trying to work out the open adoption agreement. That's the majority. I mean, I wish it was the other way around, but it's not.
Yeah.
So we're going in there as defense counsel. I've already explained the benefits of a relinquishment. So we're now going to try to get some terms. One, why does the DA need to be there with the foster parents? Is the DA going to give the foster parents legal advice? Because, I think in all my open adoption agreements, which I've done a lot, it's a form of mediation. It's usually me talking to the foster parents, trying to get them to agree to something without me giving them legal advice. So when they're in that room, and we're talking about open adoption agreements, what is the function of the district attorney's office? Because I've seen where they get in the way of some of my open adoption agreements, especially when you're dealing with family members. But anyways, what is their function?
So I'll tell you a story to illustrate how you never know as a mediator what you're walking into. And this story, I think, illustrates a lot of points that I've already made. So I had one in April where second removal, so case was fairly early on moving in the TPR direction. The children were with maternal grandparents. So I know it's a mediation to possibly discuss post-adoptive contact terms. So I do all my prep work, which is very important, which I definitely want to get to, why it's so important when the mediator calls or emails you to please call or email them back. Because I couldn't have done this mediation if I had not had pre-mediation work with everybody. So when I talked to the DA, she said, these grandparents, grandma should have an Academy Award. She has come into court, she is high drama, she's very accusatory, towards her daughter. How could you have done this? If that happens in mediation, we're going down in flames. Heard the same thing from Parents Council, but Parents Council said, look, my client, I think, is finally coming around to, she definitely wants to reunify with her children. She's in drug court, but she's not going to make the timelines. She's not going to be ready. So she's really coming around to, I think the kids need to be with my parents. So that's I think, what we'll be discussing at the mediation. So did a lot of prep work, had a really nice call with Grandma, and talked through what would be helpful behavior in a mediation and what would not be helpful behavior in the mediation, and walked her through the process of everybody sitting in the same room and having this conversation, and that we weren't going to be talking about the past, because that really seemed to derail things. And so Grandma said, okay, I can do this, I can be ready, but I'm telling you, I'm going to bring my crochet with me, because I found that if I start getting upset, I'll crochet. I said, okay. So everybody writes for mediation. I bring parents into the room to orient them. And so I walked them through the process. This is what it's going to look like. This is confidentiality. This is the agreement. Do you have any questions? What are we looking at? How do we want to start this? Well, I want my kids back. Ooh, okay. So completely different thing than I've heard from her counsel. I want my kids back. I want to talk about getting my kids back. So suddenly the DA becomes very relevant in that, because she's going to have to walk through, this is my legal view of the case, and here's what a TPR would look like. So that hopefully answers your question right there, is you never know what you're walking into. But that also made me realize, okay, I don't think that's going to be a helpful conversation to have grandparents in on. That's going to rile Grandma up on. So have to shift on the fly, go out to grandparents and say, for right now, could you guys just stay out here? We'll bring you into joint session when it's appropriate. So we shift. So everybody else comes in the room, and Mom starts out, and suddenly she's a lot more gentle. Well, I really would like to have my kids back, if it's possible. And as she talks a little bit more, she says, I just want to sit down with my parents. I want to talk to my parents. There's been a lot of hurt feelings in the past. I want to talk about them. I want to talk about what's happened. And I think if I do that, I can move forward. All right, so we got to shift on the fly again. Well, who would you like in the room? We got all these people. Can you really have this conversation in front of everybody? I just want it to be me and my parents, which was a great surprise to her husband, who she had been holding hands with the whole time. I thought, okay, so there's something going on there. She kicks her husband out. So I go out to Grandma and say, okay, Grandma, we're gonna talk, and what your daughter really wants to talk about. I know I said we wouldn't be talking about the past, but she really feels she needs to clear the air. Well, I don't think I can do that. Well, let's try and do it in a non-judgmental way. La la. Okay, so now we go back in the room. We've got Mom. We've got her parents. Grandma is furiously crocheting. And they're right across the table from each other. And the first thing that daughter does is she said, I'm so sorry. I am so sorry that when I got so angry with Lily, the oldest child, she beat her, I should have called you. These parents she'd never apologized. This case was months old. She'd never apologized. Grandma's still crocheting, and I'm thinking as the mediator, Grandma, put the crocheting down. This is a moment. Look at your daughter. This is not going to work if you're... And a minute later, Grandma puts the crochet down. She stands up. She walks around to the other side of the table, and she gives her daughter a huge hug and says, we love you, and we just want to help you through this. And boom, magically, daughter didn't need to spin through the whole past. She just needed that moment. And then we sat down to look at what post-adoptive terms could be. I said, well, what do we do with husband? I don't want him in the room. Okay. So then I got to go to explain to husband, well, for right now, we're just going to do it this way, and then you can come back in at the end. It just kind of illustrates what a changeable, fluid process this is, and how you never know what to expect. And that's why we need all the players there. And if it comes to a point where maybe we don't need the DA there because we really know we've come down to post-adoptive contact terms and the DA is comfortable not being there, then we may shift it that way. But I never know walking in the room what I'm going to have that day. And I need to have, the one I came down here and did on Thursday where we co-mediated and we didn't have the DA there, it happened to come to a point where I really could have used that DA. I really needed somebody to walk through and give a reality check. I can't do that. I'm a neutral. I can't have other counsel do it. I have to have the person who's going to put that case on do it. So that's why, and I kind of need to move on so I make sure we make all of our points. But keep in mind it is a continuum, and give feedback to your mediators and give feedback to the judges and hearing masters about what will work for you in this process, and we'll get the computer and the printer and allow that option because I want it to be what works for people. So just let's go through who's there. Who's at the table? Parents and counsel, DA or AG, you may or may not know in the rural jurisdictions, once a case has gone through its dependency piece and it's time for the TPR, it actually goes to the AG to prosecute that TPR. Funky, weird, but that's how it goes. Social worker and supervisor, we need somebody who can sign on the dotted line. We need to have a supervisor there. Children's attorney, CASA, maybe foster parents or prospective adoptive parents. I've occasionally had therapists. If this is maybe dealing with some kind of visitation or permanency plan or post-adoptive plan where it needs to be therapeutically recommended, we may have a therapist. We may have a tribal representative if it's an ICWA case. And sometimes we may have children, and I just wanted to be able to touch on this piece. We don't usually have children. If it's the initial petition stage, it's not appropriate for children to be there because it's not something that directly involves them. It's whether or not these parents are going to submit to the petition, not a good place for kids. If it's a placement case and we've got older kids and they really want to have a voice, we've had them there. We're going to work really, really, really closely with Parents Council on that and walk through that and make sure this is an okay place. And we're going to talk about what is it going to look like. And is there going to be a time during the mediation where we excuse the child? And quite likely there will be.
Oh, this is causing issues. I mean, we might as well just get it right out on the table. Right? You guys got to back me up here. We are client directed. We cannot make decisions, or do that without our clients. Now, we have little kids in which we use substituted judgment, but kids are parties to these proceedings. They're parties. And they have a legal right to be in court. I mean, they have a legal right to be in court.
I understand that.
One of the big issues is that we don't get enough kids to court for transportation reasons. But they have a legal right. These cases, first of all, there's nothing that happens in these that they don't know about because they live through them. And the second part of it is that, they have a right to know what's going on. And if there's part of the decision-making process that affects kids, we can't participate without being directed by the kids.
So what often happens, at least up north, is that there are a lot of conversations between children's attorneys and their clients before the mediation about what's acceptable, what's not. The last thing we want to do is create something that is more damaging for those children. So let me give you an example. And I'm not saying children are excluded. I'm saying this needs to be walked through and looked at very carefully. A mediation I did recently, dad was being transported from prison, so he's all shackled up, which I know happens in hearings and stuff, but these children had not seen their father in 7 years. And up until 3 months before the mediation, they were told their father was dead. These children were older, 14, 15, 16. They had a ton of anger against this dad. There was talk with children's attorney about the kids coming, but we realized in our discussions they wanted to come to confront dad. And we all, as we walked through it, realized this is not going to be a healthy place. We're not therapists. The environment sometimes can be therapeutic, but we are not therapists. We are not appropriately trained for this. So we found another way for those children's voices to be heard. Instead, they sat down and wrote letters. They wrote letters to both of their parents. And that's the thing. That's what we started off with Parents Council.
I just think we're going to have to agree to disagree on this one.
Yeah, and that's fine, and walk through it with your mediator.
I mean, we've taken the position that whether a child participates is a decision made with counsel and client, you know, and that's our approach, whether the kid stays in court or doesn't. There was a period of time when kids were being objected from court, and we finally reached a position where, you know, the decision, we ask a kid, we always ask a kid, we know kids are going to be in shackles, we ask them, how do you feel about that? Or, you know, we prepare, that's part of our function as counselors.
Sure.
And so I think that whether our clients participate or not, it depends on the issue. I agree if it's an issue that doesn't affect the kids' lives, that's a different issue from where it does.
Sure.
You know, so I think we're just going to maybe have to, you know, as they would say, put that one in the parking lot, because I don't know that we're going to reach agreement on that one.
Well, and I don't think we're at disagreement. I think what we're at is it has to be looked at very carefully. You got to walk through it. It is different than court. It is very, I mean, you know, as a mediator, it's very different than court. I know under the statute, children are allowed in court. This is a little bit of a different process. So you need to walk through it very carefully with your client and with your mediator, and create the process that you create that's best for it. Very likely, though, the children are not going to be there for the entire mediation because it can be traumatic. So those are, I think it has to be dealt with very, very carefully.
Help me out, I'm struggling a little bit. Where would the children's, I mean, if we're doing a mediation to get rid of, to change the verbiage of a petition, the children's, I guess, their voice, the parties, the district attorney and the parents.
Right.
And then if we're doing an open adoption agreement, I've had children's attorneys get really upset at me because I didn't involve them in an open adoption agreement between my client and the adopted parents. And I told them, I don't need involvement. So I think
our
these
parties
type
are
of
third-party
I
beneficiaries to
get
those
that,
contracts.
I get that, but they're not parties to the contracts. And if we're doing a mediation on changing verbiage to the plea, I don't think children need to be involved in that.
I'm not disagreeing with you on that one.
So I don't know how much they play in these type of mediations that we're mostly going to be doing.
Yeah, it's very unusual for us to have kids, and kids counsel is fully on board with that. So obviously something that may require further discussion and really looking through. Just wanted to mention the mediator's nightmare of the unexpected person showing up at mediation. Yep. So we're always so happy when that happens. Just to let you know, the general protocol on that, we're gonna find out who is this person, what's the role there. A lot of times people will bring witnesses. So we'll need to talk through, this isn't the time for witnesses. It's a time for the parties to the case to be sitting down at the table. If you could just, would it be okay for you to maybe leave your witness, supporter, friend in the waiting room, and we can take breaks, and you can check in with them. And every time we do that, they never check in with them. They find as soon as they get in the process, they're okay. Sometimes it's helpful for that parent or someone to have a supporter. Maybe it's somebody that the department has worked with really closely. Maybe it's a significant other who has a really calming and good influence. If that's the case, we're always going to check. If it's a non-party, we're going to check with everybody, what are your feelings on having this person here? And then we're going to talk to the supporter and say, your job is to be seen but not heard. Your job is not to come in and advocate for this person, and you're going to be seen and not heard. And if that role changes in the mediation, I'm going to call timeout, and I'm may have to ask you to leave. So that's how we deal with those. I don't know if you guys have any more input on the unexpected person. And all right, we're going to skip the video. It was silly anyway. So as you can see from that list of parties, these can get huge. I've had as many as 15 people in the mediation room, and it can involve interpreters and people on the phone and all kinds of things, and it can seem rather unwieldy. That's why our pre-mediation work is so important. Getting filled in on what things are going to look like really helps us manage this crowd. We have lots of tools to manage the crowd because our job is to take parties that look like this and create this. So That's what we're working for. You know, sometimes you can use the sappy emails that your mother sends you 10 times a day, right? She's always sending me these, and I'm like, oh, I can use that picture. So pre-mediation, just so you kind of understand, the mediator is going to receive certain pleadings on the court, not the whole file. We're going to receive, if it's a petition case, we'll receive the petition. If it's a TPR case, we're going to receive the TPR petition and then usually the latest court report. But nothing else. So there's obviously been tons of history that we are not privy to. That's why we need to talk to you. So we're going to contact stakeholders. The program breaks down stakeholders versus non-stakeholders. Stakeholders are all you guys. You are the professionals who routinely participate in these cases in mediation. The non-stakeholders are those who don't. Parents, foster parents, prospective adoptive parents. That's just the lingo that's used so that you know what I'm talking about. We're going to contact you. Please call us back. We need to strategize. We need to know. We need to explore if there's domestic violence. I'm going to talk a little bit more about that. We also may be contacting non-stakeholders. The most common ones we contact are foster parents, prospective adoptive parents. Please know, and this is a point I'll be making this afternoon with the social workers, we don't have that information. We don't know who they are. We don't have their phone numbers. We have to rely on social services or the DA's office to get that information, but I can tell you it is incredibly valuable for us to talk to these folks. I've talked to so many prospective adoptive parents who are so nervous and they're unsure, they have no idea what we're doing. And if I have 20 minutes, of their time ahead of the mediation to walk them through it, to help them understand that it's voluntary, to, what are you concerned about, any of those things, that's going to make our mediation go so much better. So call us back. We usually don't, in our protocol, contact the parents. Just because we have found, as a lot of you know, it's kind of an unreliable element of the population. Parents are often moving, phone numbers aren't good, they aren't even contacting you. So we generally don't contact them pre-mediation. That's why we sit down with them before we start session and orient them right in person, right there. It works better anyway than to talk to a parent over the phone on the process. I've just decided myself to skip the break so we can get through this faster because of this point. So I hope everybody's on board with that. I want to talk a little bit about domestic violence. A challenge in these, because I know a lot of these cases involve DV. So we're never mediating the issue of violence itself, just to reassure you. That is never happening in these cases. But domestic violence can still play a huge role in mediation because mediation is about self-determination. And if you've got a DV element in that room, it may affect the victim's self-determination. So we need to be aware of what's going on. So we're looking to the stakeholders. First of all, alert the court if there's DV in your case. Now, I know a lot of these, they can tell already. They know it from the pleadings, but we also know in this work that you may suspect DV, but it might not be in that court paperwork. You just may know about it from talking to your clients, from observing how they've interrelated. If you think this is a case where that domestic violence can really is not going to work well for the mediation process, and you've got a judge who's ready to send your case to mediation, please speak up. Not every case is appropriate for mediation when there's domestic violence. So you can stop it right there on the front end. Please let your mediator know. We have different ways of dealing with domestic violence. We're going to do things differently than if there's not. We're going to do things differently if they're still a couple and together, or if they're apart. All of these things are pertinent to how we're going to structure our process, and it takes some strategy. I want to know, well, these folks are together, but dad has a huge effect on mom's decision-making authority. If I know that, I can do certain things in the mediation to meet separately with mom and counsel to make sure, to check in with her, how is she feeling. So some of the strategies we use, we may completely separate the sessions. We'll use this if there's been past DV and they're not together anymore. There's no reason to hold that session together. We'll bifurcate it. And by doing that, we may tell mom's counsel, okay, we're going to start with you at 1:30. Dad's counsel, don't come until 2:15, 2:30, because you're just going to twiddle your thumbs in the hallway. We want to know these things ahead of time so we're not wasting your time. We may have to do shuttle mediation. We may caucus, especially to check in with the victim. We may use strategies like having the victim arrive 10 minutes after the abuser and leaving 10 minutes before so that that victim does not get cornered in the parking lot. We're going to make sure it's going to change our seating. We want to have the victims closest to the door. This is a time when we're very likely going to allow a supporter, victim advocate. They rarely bring them to the mediations because they have their attorneys and they usually feel comfortable in that. But if they need a supporter, then we're going to allow that. I've worked out signals between victims and myself. Give me a signal. It can be, lift your finger if this isn't working for you, if you need a break, anything like that. We may be asking the victim, what are some other ground rules that you think would help us out in this mediation session with the abuser? Sometimes you may ask to have that bailiff. I think you guys are mostly do you mostly have the bailiffs in the?
No, only when there's
incarcerated. Okay. But you may have one where there's not incarceration, but you feel the need to have that bailiff in the courtroom.
I did request a bailiff. Keep a close eye on one case.
Yeah. And that makes the victim feel safer as well. And then we're going to be checking in. We're going to check in with the victim before the mediation. What's your comfort level with any of this process? Is this a safe process for you? We're going to be checking in during. How is this working? Maybe that victim's going to give me a signal, or maybe I'm going to be saying my gut is telling me I don't like the dynamic in this room. And I'm going to say, now would be a great time to take a break and I'll chat individually with each of you. And I'm going to talk to that victim and say, what are you feeling? How is this working? This is what I'm observing. Or maybe I'm going to talk to that abuser and say, this is meant to be a process where everyone has an equal voice. And I'm noticing that, when I'm asking mom a question, you're answering for her. I'm going to ask you to please, not do that. I need to hear from everybody. And I'm certainly going to check in with her when an agreement has been reached to make sure, is this truly a voluntary agreement? Is this really what you are agreeing to? So we need to be able to plan for this. The last thing we would ever want to do as mediators is create an environment for a victim that is not safe. So it's a sensitive and important topic. Okay, back to during. We're going to orient those parents in that pre-mediation conference, and we'll orient others we haven't had the opportunity to talk to. If we couldn't reach out to prospective adoptive parents, we're going to talk to them there. Go through confidentiality, explain anything. I like to use it to understand where are you right here, right now. I'm going to talk to them about how do you want to start this? Would it be most helpful to hear from the department and hear where they are? Is it most helpful for you to talk about what your perspective is? I want to make them feel comfortable. I want to allow them to be heard, and I don't want to press them or make somebody have to start talking when they're not ready or they're not comfortable.
Margaret, what do you see the parents' attorney's role? You said you don't talk, you don't kind of explain the process to the parents so they get there. What do you see the role as a parents' attorney, kind of how to give them the overview of what mediation's about so that
I'm
they're
going to get there because that's important. After that, everybody usually is going to gather in joint session. If we're doing it a little differently, like for DV or like the grandma story, we might tweak that a little bit. And then the mediator's there to facilitate that conversation. So we're going to be clarifying and reframing, asking a lot of open-ended questions, allowing everyone to share perspective and be heard, not just parents, everybody at the table. We may be caucusing. We're going to be helping to explore options, and we're noting areas of agreement all along the way. we've already gone through this. If there's agreement, this is the current practice. And so, maybe that will be changing somewhat depending on what's going on. If agreement is not reached, the mediator needs to let the court know. You guys are usually letting the court staff know, like Lorena, whoever's.
I immediately go back to my office and write up the report and fax it to
So that the court knows, oh, all right. Yeah, this wasn't reached.
just the generic, reach mediation, we did reach mediation.
Right.
Really, to let
Right.
you know we did it, who was there, and what the basic
And
outcome
right,
was. Yeah.
right, but certainly not disclosing any of the content. This is important. If a mediation scheduled and a party no-shows, there is no second bite at the apple. Why? Because we take a hit to the budget. When there's a no-show, we pay our mediators half the fee because they've done a lot of prep to get there, and we need to acknowledge that. And also because if there's a no-show one time, there's often a no-show the second time. And so it's a one-bite rule. We only have a limited amount of funds for this program, and we want to use the funds for people who show up to the mediation.
I've had ones where my client doesn't show both the TPR and at the petition stage, and we were able to resolve. Like them not being there was a huge benefit.
It is true. That being said, we're going to make the judgment call. If everybody comes and the parents aren't there, I'm going to be looking at Parents Council saying, what do you want to do? Is it going to be useful for us to sit down and talk to the prospective adoptive parents and find out what they're offering? So thank you for clarifying. It doesn't mean we don't have the session. It might mean we don't. So there are times we absolutely 100% have to have them there. I've had sometimes parents not be willing to come down to the courthouse because there's a warrant, so they may call in. And we'll have them on the line. We're going to do whatever we can do to hold a session because everybody else is there. But if it's one where they don't show and we can't go forward, it's not going to get rescheduled. But yeah, if we can make it go and get an understanding or get a game plan, then yeah, we're gonna use that time. Interpreters, we're going to use them whenever possible. And this was a question for the court. There was a mediation the other day, apparently, where foster parents needed an interpreter, and there was a lot of confusion over who was supposed to provide. The mediator was first told social services would provide the interpreter. And then when he checked with social services, they said, oh, no, you're supposed to. Well, we don't know how to provide an interpreter.
It'll be resolved. The mediations, if they're at the courthouse, the court mediators would prefer that. If they're there, if we go to different sites, then we'll address the issue with DFS, but the court will make interpreters available to them. If we know, you gotta let us know, that's the thing. If you don't know and you show up and it's a busy day and you want a Spanish interpreter, you call them a mediation at 3 o'clock, you may get a mediator, you may get an interpreter, you may not, so let them know if there's somebody that needs an interpreter, especially if it's different language, You're talking to the different dialects, they're not available, we gotta get, days advance if you get someone that
Right.
is unusual or something,
That's another reason for us to need to have some kind of contact with the respective adoptive and foster folks. I've had really good luck, but having that conversation the night before would be very enlightening. The other parties all have attorneys, and hopefully they know if they need an interpreter. But
Right.
the only time we would end up finding that out would be with a third party like the foster or the adoptive.
So it's something that I'll be stressing with the social worker training this afternoon because they're the ones who are going to have that knowledge, and obviously we need to arrange that in advance. Inmates who are transported, my understanding is it's Parents Council's job to make sure that there's an order for that inmate to be transported. So
In our TPRs in our hearing master courtroom, they don't even have me do an order to transport. If they're there at the initial appearance where I am able to confirm, then the marshal with them takes note of it.
Oh, awesome.
And there's no other additional order that they're asking for, requiring, and we ask them on the record, do we need a new order to get them to mediation? And they say no.
yeah, that's great. Just so you all know, up north, if we have an inmate, even if it's somebody in custody 10 minutes away at the jail, they don't get to come. All of our inmate mediations are via phone, all of them, which is a huge disadvantage for us, but we don't get that. So you guys are lucky that you have a system in place that allows the inmates to be there in person, because it makes a big, big difference.
And that's one of the reasons we decided, at least this point, to have it at the court hearing, because there's a lot in custody. They're not going to transport to an attorney's office.
Right.
We've got security issues and
Not
stuff.
gonna
So the
happen.
courthouse, they were fine because we got backup security, we got
Right.
holding pens. So I mean, that's another reason we did it, because we suspect them to be several in custody to make sure that was safe, but also they would transport, because if you're doing it at some other site, that's a whole different thing. We'd have to bring up with the commanding officer and stuff about security and transporting prisoners other than to a courthouse. That would.
Right.
So if we had those, we probably would keep those at the courthouse anyways, just simply because of the security and transport issues.
Yeah. So I don't know if you guys have had too many where that there's been an inmate issue of somebody not coming. Have you guys?
No, I've had a number of
Okay. Good. So it
Just
seems.
have extra bodies in the room.
Yeah.
Usually 1 or 2 transport officers.
Yeah.
The one thing you run into with transport is they've got to get out of here by a certain time.
That's been a big issue.
So that's,
Yeah.
I think that's probably the biggest issue you run
Yeah.
into with being in custody.
And we've been trying to wrangle with that. We've had conversations with Judge Sullivan about what do we do. We've talked about starting bumping up the mediation time, but my concern with that is it leads to great confusion. For a long time in Washoe County, our Monday, Wednesday mediation started at 9 o'clock, and our Friday started at 8:30 for various dumb court rules. It confused the crud out of everyone. Even people who came every week, they still got confused on Friday. The other thing is that we don't know when it's being set which mediator is going to be the mediator assigned. Because we had talked about, well, do we hold it in the morning? Well, I've got one mediator who drives in from Ely. And I have mediators who are busy, have busy practices, and I can't ask them to set aside a whole day in case the mediation might get set at 10 or it might be at 1:30. We're working on it because we know it's an issue, and we're trying to find an answer. So after mediation, you get the lovely survey. Everybody loves the surveys. They are so important. I mean, we do possibly up to 4 mediations a week in Washoe County, and we're much smaller. So it's a lot of the same people all the time, and they kind of groan when I hand out the surveys. They go, oh, come on, really? This is how, these are used when our programs are evaluated. They are so incredibly important. Please remember, they are anonymous. I know everybody says they're not anonymous because they make me identify the date that I'm here and what my role is. I get it. I didn't draft these. I probably drafted them differently. But they're drafted that way because when the studies are done, those who are doing the data crunching, they want to know. They want to know who said this. Was it, a parent? Was it the district attorney? Was it a CAP? Who said this? And they really are anonymous in that they go right up to me. So the mediators don't see them. They're not reading your comments. So please, please be candid. They go right to me, and I look at every single one of them because I want to know, how are things going? Was there a problem indicated in this survey that maybe I need to chat with the mediator about? I'm not going to identify the case. I'm just going to say, hey, looks like, or I may try and pick up the phone and call you. So they're not anonymous in that way because I want to use them for troubleshooting. Just recognize, please take the time to fill out these surveys because they really are imperative to the continuation of our program. If we don't get surveys, we can't do any of the analysis, and without that analysis, we're not going to get continued funding, and the program will have to find other funding, which is quite a challenge. So let's talk about stakeholders. Back to Judge Sullivan's question. I think I probably stressed to you how many times today, I need you there. Please come. Please plan on 3 hours. Hopefully it won't go 3 hours. Sometimes it does. My fastest has been 45 minutes. My longest has been a good 4 hours. But the payout is on the back end. It takes time, but you gain way more time than you put in. Your client's attendance is also vital. Please do not decide that you're not going to attend and send your client with, well, here's your instructions. Yeah, some of you are like, are you crazy? But it might depend on who your client is. I've had this happen before, where, well, I'm not going to be there, and so your job is just to, maybe listen, take notes, and let me know what happened. That's not going to be a good mediation, because number one, you're not there. Number two, your client's there with a limit, and so there's not going to be this dialogue that there needs to be. So everybody needs to come. We talked about inmates. We've had some no-show issues, not too many. One of the things that is supposed to counter that I don't think is happening, so hopefully we can get it rolling. We do have a program brochure, and the idea behind these brochures are there for parents, although they could be handed out to other non-stakeholders because they explain the mediation process and what to expect. But on the back, they have a date, a time, and a place. It's meant to be sent with the parents right out of the courtroom when that mediation is set.
Where are they?
Well, apparently you guys need more, right?
I haven't seen them yet.
Yeah, okay. So we will make sure. And if you guys want to take any of these today, just to have some, feel free to take them. But yes, that's what's supposed to be happening, and we have found that increases parents' attendance at the mediation because they leave with something tangible like that. And also, if you're able to talk to parents ahead of time, they're more likely to come to the mediation. And I recognize sometimes you try and you can get no contact. I get that. But if you can, that definitely helps with attendance. So we're going to be strategizing. We're going to talk about domestic violence. I need to know, all the mediators need to know, what are the roadblocks, what are the issues, what are the personalities. If I needed to understand that whole grandma dynamic in my crocheting case, so that I could figure out what's my process and where am I going to seat people. There's a whole psychology behind seating. And you want to seat people in the way where it's not going to be adversarial, who's really going to be talking to whom, do they need direct eye contact. We think about all of these things before we walk in the room. So that's all part of that strategizing that we need to do with you. Please be prepared yourself. Please have reviewed the file, and please meet with your client. Start talking. If you're, really for anybody, if you're DA, start talking about with social workers, what are the concerns, what are you looking for? If you're a CAP attorney, if you're a parent's attorney, start talking to your clients about their interests so that they're prepped, they're really thinking about what do I need from this, because that's what we're going to be doing in mediation. Start talking about what are the other ways that you might be able to resolve. When people start thinking about that before they walk in the room, it's easier to really open up that door. So prepare your clients. Explain the process. Really, really bring home to them, this is not courtroom. It's going to be the opposite of court. This is going to be different. If you didn't like court, you're probably really going to like this process. Really sell it to them. Have them be prepared. What do they want to say? What do they need to convey? Ask them to be genuine and honest. And I know that can be really challenging because they often feel burned. Parents feel burned. It's so common for parents to have spoken with a social worker thinking it was confidential and then to see it in the court report. Well, I understand why that happens. That's the way it works. But for them, they're like, whoa, wait a minute. So we try and spend a lot of time ensuring they understand this is a different kind of confidentiality. This isn't going to end up in a court report. This isn't going to be talked about in open court. This is different. You really can be open and honest. Be open to the discussion and different resolutions. Please help them understand it's going to be future focused. It's going to be where do you want to go from here? What are you looking for? At the beginning, they're looking for getting their kids back. At the end, they may still be looking to getting their kids back. Or maybe they are able to kind of step back and look at that bigger picture, that really what's going to be best One of them, one of the speakers in the video talked about having, I think it was the DA, having parents just through the mediation process finally come to that place where they realize it's going to be best for me to let go. That's how these can be so moving and impactful, because I can't imagine having to make that decision. But sometimes being in that environment really fosters that and allows it to happen. Sorry, I'm just brewing through these, but so please bring the file. This has been an issue in Washoe County. Well, if you're a social worker, please bring the file. If you're a DA, bring the file, because sometimes, often at petition cases, what will come up is when we have to revisit that past piece, some conversations, some of the notes, those things might become part of what we need to talk about to move forward. And I've definitely had folks come without the file and they can't answer the questions. And it just puts up a roadblock that doesn't need to be there. Be prepared for the parents to do some venting. Part of our job as mediators is to let them do some venting, but to not let it get to the point where it is not constructive. So they need to feel heard, but we're not going to go down the rabbit hole. Our job is to keep everybody focused. But to let that happen, and just remember, they really have not had a chance to fully tell their story. So it's going to be so important here. Legal counsel, be prepared if you need to discuss the legal aspects. This doesn't mean advocacy. It just means here's how the presumptions work. Here's the timeline of the case. We have to do all this in 12 months. Or here's the difference between relinquishment and termination of parental rights. Sometimes we really, really need legal counsel to walk through things, because that's what it's going to take for a shift. So be prepared. You may not have to, but be prepared if that's where we are. We've talked about not advocating. One of my mediators has told me that in a lot of his mediations, some of the legal counsel doesn't participate. That maybe he'll have, not to pick on you, but some of the DAs not participating. I think maybe thinking the view is, well, this is really about parents being able to have their voice, or maybe my social workers. We need everybody. We need all the minds in the room, because a lot of times the legal counsel can come up with options. They know the statutes better than anybody. They know where the wiggle room is. So everybody should be developing this information. Everybody should be having this dialogue. We've talked about future-oriented. Be ready to brainstorm. I had one recently that was a permanency plan, where the permanency plan was TPR. And it was one of those where mom was, maybe some information was clicking in and she was starting to re-engage. And she came in saying, look, I want to change to the permanency plan. I really want it to be concurrent. And I want to go back and see my therapist. I'm ready to do that. And social services said, you know what? We're great with you going back to the therapist. We'll pay. We'll set it up. We think that should happen. We're not going to change. We're not going to change the permanency plan. We were way down the road here. We're not going to do it. And it became a sticking point in this mediation, where nobody could get past that. So we tried caucus for a bit. That wasn't helping too much either. And so I thought, all right, I'm going to pull attorneys together. I pulled the DA, parents' attorney, children's attorney. And we kind of sat down and I said, all right, where are we stuck here? And by, bless you, by brainstorming and looking and once again exploring those interests, parents' attorneys said, why can't you change it? Why can't you change it? Their client's just not willing to. Well, my fear is you're not going to change it, but we don't have another hearing for 3 months, and here my client's going to be working all this, and the plan is still going to be TPR. I'm not comfortable with that. Well, DA said, what if we set a status hearing? Let's set it like 6 weeks out. So we give your client plenty of time to go back to the therapist and start working on it. and then we'll let the court hear. Well, that met our needs, case resolved. But sometimes it takes some creative thinking like that. It's a good example of getting behind the position and looking at what's the need, what's the interest. So everybody needs to be in those conversations. That could not have happened in that mediation without kind of the legal minds figuring out, well, how do we make this happen? And just be patient, allow that time, let it unfold. It is a process. It's not like negotiation where it's, here's what I want, here's what I want. It's that the assisted negotiation takes a lot longer to develop. So let's just touch on confidentiality. We're almost through. It is considered a confidential settlement process under 48109. Everybody signs that confidentiality and agreement to mediate. That confidentiality agreement does list those exceptions. Obviously, we cannot fail to report any new allegations of child abuse, elder abuse. We're not going to fail to report if a mediation participant makes a threat of harm. That's only happened once in our program, but it was a threat by father saying, if we go to TPR trial, then I'm going to, kill the mother or something like that. So we had to report it because it was pertinent to what might happen in the future. Any written settlement agreement is considered an exception. And actually, it can be written, we consider written to mean put on the record as well. It's the same equivalent. It's easier to consider it an exception rather than trying to find it some other way, because obviously if it's put in writing or put on the record, the court's going to know to an extent what happened in the mediation, but everything leading up to that agreement still stays confidential. And then there's always that pending criminal case issue. I've never had it happen, but someday it might. We cannot guarantee that if anybody in that room were subpoenaed as part of a criminal case, we can't guarantee the confidentiality of what happened there. It's just a gray area, and we don't want to mislead people because sometimes they have criminal cases connected to their dependency case. So we keep that as an exception. Any questions over the confidentiality?
The DA could, though, easy enough.
DA could what?
Any pending criminal case.
The DA could what?
Could waive, make it so it's confidential, that could be used against them in any future pending criminal case.
Well, I think the issue with that, I don't know how things are structured down here, but the issue with that is up north is the DA on the dependency case is a civil deputy DA, and the DA on the criminal case is a criminal deputy DA, and the two do not talk. So they will never waive, a civil deputy DA will never waive confidentiality for a criminal DDA's case because it's not their case. Do they? So you guys have a different system.
We went up to the DA himself, Mr. Wilson, and said, here's the problem on that we're going to get a commitment that if they say that, for that reason, because we had that problem, that's how we got it resolved, because I talked to Mr. Wilson himself, said we need to resolve it from the top dogs on that to do that. We normally do it if they plead out, would say the fact they plead out cannot be used against them in a criminal case.
Oh,
Any
sure.
statements they make, those kind of things, but I think you talk about them being subpoenaed. If they're getting subpoenaed
Right.
to testify,
That's what we're
subpoena
talking
mom to
about.
testify against dad in a criminal case, it's really not about what happened in mediation. It would be, is that kind of what you're talking
Right,
about? If they get-
right. Because our criminal deputies they don't use submission or anything in the underlying dependency as evidence either.
No, I know, but what the judge saying is also is, and I've done it before even entering into a plea on a petition, anything they say to a treatment provider can't be used in a criminal case, even though they haven't even pled in the underlying petition. But also afterwards, we have them so that anything they say to the provider can't be used in the pending criminal case. The same could be simply done in a settlement conference. You get the DA to say anything that's said, settlement conference can't be used.
Yeah, I think it comes down to DA philosophy. So
Sure.
we don't have that up north,
Yeah.
but sounds like you do down here, which
It
is
is.
great. Yeah, absolutely. Helps the conversation go along in the comfort level. So we'll just check in overall as a program. Hopefully you've really gotten the idea that what you guys are participating in is pretty revolutionary. There aren't a lot of statewide dependency mediation programs in the United States. We're hoping to be the model for a lot of other states, and it's pretty exciting to be a part of that. So far, here's what I know. This is a work in progress. We had a very slow start to the program. We started in fiscal year 2017, 2018, so July 1. In the first quarter, we did 6 cases statewide. None of them here. It was a little slow. The crickets were chirping, but we have definitely pressed the gas pedal. We've encountered some issues along the way here. There's sometimes been some scheduling confusion. Sometimes people came to mediation and there was no mediator there. Paperwork didn't quite make it through. We've had some double bookings sometimes. Getting everybody to attend, I think, is still an issue. Because I came to one Thursday and everybody wasn't there. Mediators receiving sufficient information, sometimes that's been an issue. And a lot of times it's an issue because they're not getting calls back. So all of that is a work in progress still. And just so you know, for issues like we've talked about today, the program holds a monthly conference call with the court to say, okay, where are we on this? Can we do this? This has come up. We're always trying to deal with these bumps as affirmatively as we can. So if you guys all encounter bumps, I've got my number at the end of this. Call me up. I'm happy to talk to you about it.
You can send them to me as well, because I call, of course, so any concerns you have, like, you have about getting some on the record, I was unaware of that. So if you bring it up to my attention, we'll make sure we get that addressed at our monthly meeting.
Yeah, we want it to work. So we've now, I don't know, through a couple weeks ago maybe, done 66 mediations statewide. 56 of those, or 85%, have resulted in an agreement. That's an exceptionally high agreement rate, which is, it's to me pretty astounding. We have done mediations in the 1st, 2nd, 3rd, 4th, 5th, 8th, 9th, 10th, 11th judicial districts. It's our goal to do a mediation in every single judicial district. So we're missing a few, but some of these jurisdictions are really, really small. They don't have a high, they might get 4 cases a year. But it's pretty amazing that we're doing mediations in rural locations in Nevada that have never seen mediation before. That's why this is revolutionary in a state like Nevada. There are other states that have statewide mediation, but they have 50 counties and bazillions of people. We don't have that here. So the fact that we're introducing this all over into these rural locales is pretty darn cool. So the NCJFCJ will be assessing this program. Right now they're assessing it just for the process. How did the implementation of this go? How is the process working? We don't have enough mediations yet to do an impact eval. It's the impact evals that note those kind of things about engagement and reunification. They are doing that in the second JD, and their preliminary findings really are matching their earlier findings. All of those really good results we've had still happening. As soon as we have enough cases in this statewide program, they'll be doing the same. I like just to read the survey comments. There's that one question, what did you find most helpful about the mediation session? Here's a sampling of some of the answers that we're getting. I mean, honestly, the surveys have been really good. So I hope you're all telling me the truth on these. And if you want to say something negative, I am 100% fine with that. Parents have said things like, the chance to be heard was very helpful. The mediator helped me understand. Sometimes just having that neutral, really uninvolved person helps the parent. We found some common ground. Parents, attorneys, it was a forward-looking session and did not get caught up in the differences. That's the difference between trying to negotiate without a mediator and with a mediator, because it's much easier for a mediator to keep people on task. First-time parties could have a calm discussion about the child. CASAs, I believe the program should continue. Yay, CASAs! District attorney or attorney general, parent was able to express himself, and we could see different possibilities. Really good example of that ability to sit down together, where different options became apparent. Being able to tell mom the uphill battle she would have faced and working out open adoption agreement. A good example of when you need the reality check, when you really do need that DA to go through the case. Social workers, supervisors, this program is very helpful, saves time and resources. Good process to discuss the case without court involvement and lots of room for open discussion. I'll find out this afternoon, but I think social workers generally really like this process and recognize it kind of, no. Maybe depending on the social worker. All right, so what's in the future? We're almost out of funding, which is actually a really good thing because our goal was to run through all of our funding for this fiscal year so that we could apply for funding in the next fiscal year. We had to show, look, we're using this, it's working. That's why things like surveys are so important. So we're right now applying, and I have been told that it looks exceedingly good for our funding, and that in fact we should get more funding than we got last year because we have been able to show we're doing all of these mediations. So as far as we know, we're going to get funded, and we'll have more funding for Clark County in that because you guys are doing, well, between the second and the 8th, obviously those are where most cases are being done. Judge Sullivan brought up SB 432 that has this language about court-ordered mediation. It's obviously permissive language, and it's narrow because it's only talking about TPRs with the post-adopt. But from a program standpoint, we love this because it introduces the idea of dependency mediation to the legislature. The big scheme in the end is to take all of this data, all of these reports, and march to the legislature and ask for funding for mandated dependency mediation. That's the ultimate idea. Here's my contact info. Contact me for anything, positive or negative. That's what I'm here for. Just a couple parting thoughts from judges. Judge Liu says dependency mediation program has been a successful tool in resolving highly emotional and difficult cases. By mediation agreements prior to the settlement conference, the program has greatly assisted in reducing congested court dockets. Second, JD is really on board with this program. Last slide, last comment, but I think it's a really beautiful comment from Judge Walker. In cases where the dependency process results in termination of parental rights, mediation is likely one of the few humane processes which we can offer parents. In the great majority of cases which remain, mediation is reaping benefits through earlier participation of parents and the tantalizing possibility that mediation will be a significant tool with which to accelerate the safe and effective reunification of families. The dependency mediation program is a great example of how a modest investment of dollars early can reap untold rewards in positive outcomes later. So everybody pat yourselves on the back for being part of this program. I know we've rammed through a lot of information, but I so appreciate your being here. And thank you. And let me know maybe afterwards if you have any questions, since everybody else wants to go. Thank you.